Morning.
Good morning, Mr. Commissioner and members. Mr. Commissioner, as arranged previously, we have the GEPF coming to this commission this morning. Before I proceed, can my learned friend just place himself, his junior, and his team on record?
Mr. Chair, members of the Commission, I appear on behalf of the GEPF and its Principal Executive Officer, Mr. Sithole, who sits to my right. I, for the sake of the record, am Cedric Pakrin, and I appear together with my learned junior, Mr. Raymar Skuman. Please, you.
Thank you, Mr. Pakrin.
Sorry.
Do you want me to hand it in?
Mr. Commissioner, before we proceed with the formal testimony of Mr. Sithole, may I, as a preliminary matter, with your leave, just deal with the following. It was brought to my attention this morning by the media department of this commission that an article appeared in the city press yesterday under the caption, "Moral Hypocrites." And there are pictures of Mr. Gordon, the public protector, Mr. General Holomisa, and Ms. Marcus, a member of this commission of inquiry. And it deals with, in bold, it is important to caution politicians, public officials, and those wielding power that we shouldn't be blinkered or dogmatic in our public discourse. It starts, I'm not going to read the whole article, but it deals with General Holomisa's statement on Harith. And it carries on to state the following. Holomisa's apparent overzealousness was almost outdone by Commissioner Jill Marcus, whose assertion of a conflict of interest by erstwhile Deputy Finance Minister and Harith Chairperson Jabu Moleketi was as ironic and pious as it was self-serving. In fact, there is no government policy that forbids public officials on vacating public office from taking up paid positions in companies operating with economic sectors they once oversaw. Marcus's apparent hypocrisy belied the fact that she isn't known to have served any cooling off period herself when she assumed the helm of ABSA on her departure as governor of the SA Reserve Bank. Now, I need to place on record, Mr. Commissioner, there are things like matters of fact and facts that matter. First of all, the facts in this article are factually incorrect. Ms. Marcus did not leave the Reserve Bank as governor in 2004, but as deputy governor. And it was only 3 years later that she joined the board of ABSA Bank. It's my respectful submission, Mr. Commissioner, that this article may be in breach of the regulations of this Commission of Inquiry, incorrectly and falsely attacking a member of this Commission. And I respectfully submit that it is a matter of such seriousness that the Commission should consider reporting this to the Press Ombudsman. Thank you, Mr. Commissioner. That's what I put on record.
Yes, thank you, Mr. Libber.
Mr. Commissioner, then we are ready to proceed. Mr. Sithole is ready to take the prescribed oath.
Yes, we've noted what you have just placed on record. I myself, although I didn't finish the article, also had a look at it yesterday whilst I was at the airport. And in fact, you are correct to say that factually that statement is not correct insofar as it refers to Ms. Marcus. I think there was a period of approximately 3 years between her leaving the one job to the other one.
That is correct.
And there was a cooling off period of 3 months, I understand, from her before that. It's a pity that, some reporters report matters without having, verified them with the person who is attacked or about whom the article is written. And that's a pity. And we've noted your suggestion that we report to the Press Ombudsman. We'll consider that.
Thank you, Mr. Commissioner. I can just also place on record it took me less than 3 minutes on a Google search to establish the correct facts. But be that as it may, Mr. Sithole is ready to take the oath.
Yes, thank you. Mr. Sithole.
Mr. Chair, members of the Commission, I should like to call Mr. Abel Sithole. He has been the Principal Executive Officer of the Government Employment Pension Fund, known by its acronym GEPF, since April 2015. He, in consultation with the legal advisors of the GEPF, has prepared a statement which I understand is in your possession and which you have read. I am simply going to ask Mr. Sithole, for the purpose of the record, to read that statement into the record, and I shall do so once he is sworn in. Thank you.
Would you stand up, Mr. Sithole? Your full names are Abel Sithole.
Abel Moffat Sithole.
Moffat. M-O-F-F-I-T.
Double F-A-T, yes.
A-T. No, A says A. A-T.
A-T.
Yeah, we've got an argument here, as you can
It's M-O-F-F-A-T.
Thank you. Do you have any objections to taking the prescribed oath?
I do not, Chair.
Do you then swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you very much. You may be seated.
Mr. Sithole, you have before you a statement which you prepared in consultation with your legal advisors. Is that correct?
It is correct.
I'm going to ask you to read that into the record. If there is anything which you feel requires elaboration, please feel free to do so. I may interrupt you. I hope very briefly if there is anything which I believe requires elaboration. Thank you, sir.
Thank you.
To mention, we might also interrupt here and there to clear up matters.
I, the undersigned, Abel Sithole, do hereby state as follows. I am a major male and have been the Principal Executive Officer of the Government's Employees Pension Fund, the GEPF, since April 2015. I was part of the board temporarily since 2014. I was appointed as an alternate to one of the trustees for a short period of time. The facts relating to the GEPF herein are only within my personal knowledge if such facts occurred after 2014. Facts which occurred prior to that are either gleaned from the documents or are anecdotal. I have graduate qualifications in business, or business administration to be specific, future studies, and also hold qualifications in international relations. And I have over 30 years of experience in multiple organizations in the areas of insurance, employee benefits, including pensions and related benefits, investment and asset management, statutory regulation and supervision, policy formulation and implementation, as well as research and academia. I am authorized to present on behalf of the GEPF. The GEPF has prepared 2 bundles of documents. Bundle A contains this statement and publicly available annexures. Bundle B contains confidential documents. In terms of Rule 10 of the Commission's rules, the Honorable Chairperson is respectfully requested to consider the confidentiality thereof.
I'm sorry to interrupt you, Mr. Sithole. Mr. Commissioner, can I please also ask that you make such an order?
I think the paragraph says The Honourable Chairperson is respectfully requested to consider the confidentiality thereof. Now, we only received the documents this morning, and I haven't had time to consider it. And I will do that, and we'll come back with an order about confidentiality.
Thank you, Mr. Green.
Thank you.
Chair.
I'm just reminded they remain confidential until an order is made.
May I proceed, Chair? Thank you. The Commission has requested the GEPF to provide comment on the following applicable to the Commission has requested the GEPF to provide comment on the following subjects: the relationship between the GEPF and the PIC and the legislation applicable to that relationship, the different mandates to the PIC, listed and unlisted investments, investments outside the PIC, focusing specifically on PAIDIF 1 and PAIDIF 2, and other investments, oversight and governance report back by the PIC to the GEPF, comment on the appointment of Harris General Partners, Harris, and Libashe Investments Group, Libashe, the view of the GPF on the constitution of the PIC board and the independence of the chairperson of the PIC board. I provide an overview of the GPF and its processes. The GPF was established in 1996. It is a leading independent pension fund and also Africa's largest pension fund, and it's amongst the largest pension funds in the world and the single largest investor in the JSE. The GEPF manages pensions and related benefits on behalf of qualifying government employees of South Africa. It is not a government institution. It is a separate juristic entity. The GEPF promises benefits in terms of the rules set out in the Government Employees Pension Law, Act number 21 of 1996, otherwise colloquially known as the GP Law. Its primary role is to protect the benefits of its members and pensioners by safeguarding their retirement benefits through proper administration and prudent investment. These benefits are determined based on a member's years of service, salary averaged over the last 24 months of service, and accrual rates set out in the GP law. And rules. The benefits are not based on contributions nor the fund's investments. The benefits are guaranteed by the state. And this happens in two forms. In terms of Section 17.3, any changes that Parliament approves or agrees to and actually create a strain on the GPF must be funded by the employer, that is the government. And of course, there's also Section 31 of the GP law, which specifically provides a state guarantee on the benefits of the GPF. The GPF is managed by a board of trustees that consists of 16 members.
Sorry, Mr. Stoller, there's a question from my colleague.
Question here. Good morning, Mr. Stoller. Good morning, Mone.
Good morning, Commissioner.
Yes. Here's a question. Just tell the Commission, when someone sort of retires, from the government, do they get paid a lump sum or a pension for the next 20, 30 years?
Commissioner, when a pension retires in the GPF, they are entitled to get a pension in the first, otherwise known as an annuity. However, part of the pension can be commuted and paid as a lump sum. I think the colloquial way that it's done is that 1/3 of the amount available for the pension at the time of going on pension, a member can choose, they don't have to, they can choose to take the 1/3 as a gratuity or a lump sum, and then the rest is then paid for the rest of their lives as a pension or an annuity. And of course, there's also a pension that is payable to their spouse. And in the GP law, spouse includes both heterosexual and homosexual partners. That's payable for them for life.
So when one spouse dies, then the pension goes to the next spouse and is paid for life?
If there are multiple spouses,
yes.
that will be the case. That if one of the spouses dies, the surviving spouse continues with the pension that they are entitled to.
Yes. Okay. All right. Thank you.
Sorry, in that lump sum, I'm assuming that there's the usual certain amount that would be tax exempt, and then the taxation would kick in as per the normal rules for pension funds?
That is correct, Commissioner. For services that are applicable to times prior to, if I'm not mistaken, 2008, the benefit is paid tax-free, and subsequently to that, then tax will be applied accordingly. As I was indicating, the GPF is managed by the Board of Trustees that consists of 16 members, 8 of whom represent government, the employer, and 8 represent members and pensioners. Each of these trustees has a matching alternate or substitute. Through representatives on the board, the members have a direct say in the important decisions such as annual increases to pensioners, the GPF's finances, and how the fund should be invested.
How are the GPF Board of Trustees members appointed or elected? And when you look at the union representation, that would be recommendations from the different unions that serve the public sector employees?
Commissioner, there are 3 processes by which trustees come to the board. The one, of course, are the ones that are appointed by the employer, the government. That is the responsibility of the minister, who we assume consults with the minister's colleagues in the different departments, especially the major employer departments like education and health. But that process is dealt with by the minister, and the GPF does not get involved in that process, other than requiring that the minister appoint the appropriate representative.
That would be 8 members.
There are 8 members, and so far, historically, 6 have been representing employer departments, and 2 are what we call experts, who are brought in for some kind of expertise that the minister believes that the fund requires. So that's the first one. Then the second one is the what we call the election of member representatives, and there are 2 parts to that. The active members, that is done through labor or the unions. They don't do it directly to the GPF. The GPF interfaces with the Public Service Coordinating Bargaining Council, the PSCBC, and the PSCBC from amongst its member unions, then of course, through processes again that the GPF is not involved in, gets the election of members to the Board of the Trustees. And there are 7 that are appointed through the PSCBC. And then there is the appointment of a pensioner representative. That is a direct election process that is conducted by the GPF itself. And the pensioners then get an opportunity to nominate in the first instance, and then from the qualifying nominees to then elect a pensioner representatives. And of course, as I've indicated earlier, each one of those has an alternate. So it actually makes for a board of a total of 32 members, 32 being full board members, and they also have, 16 having full board members, and the other 16 being alternates.
Do they attend together, or is it a substitute question? If a full member isn't able to attend, the alternate attends, or do the alternates attend as well as the full member?
The full trustees attend the board meetings, and only in instances where a trustee is not able to attend does the alternate to that board member then attend the board meetings. However, alternates also serve in committees. Each of the board trustee members is required to serve at least in one committee. So although alternates might not be serving on the board, they're quite au fait with what is going on the board, and they have access to all the documents that their principal has. Can please proceed, Chair? The GPF adheres to strict regulation in governing the obligations to members, beneficiaries, and pensioners. Its investment strategy uses a liability-driven approach that takes into consideration expected future benefit payments, the actuarial position, and the other long-term objectives, as well as the risk to the overall solvency of the fund. As a long-term and significant investor, the GPF understands that its success cannot be isolated from the development of South Africa. Any constraints on the South African economic growth will have a similar impact on the fund. The GEPF is a founding signatory of the United Nations Principles on Responsible Investing, otherwise known as the UNPRI, and the Code for Responsible Investing in South Africa, again colloquially known as CRISA. The GEPF recognizes that mandates and risk measurements are implemented in the realization that even the best manager in the world do not always make successful investments. The PIC manages most of the GEPF's equity, bonds, money market, and property portfolios. There are many other asset managers who manage some of the GEPF's other asset classes. These are disclosed in the GEPF's annual report. The GEPF has an investment committee which is chaired by the GEPF's chairperson, and I must be clear that it is not a requirement that the chairperson must also chair the investment committee. The board, after it was inaugurated, had an election of who chairs the different committees, and the chairperson of the board happened to be also elected to chair the investment committee, but there is no requirement that the chair of the board is also the chair of the investment committee, and has a management team dedicated to the execution of the board's responsibility to manage the fund.
On the investment committee, are there any external parties, or are they all board members? And how big is the investment committee? What expertise? And while you're looking at it, sorry, what are the criteria by which you decide that the GEPF will make a direct investment using its own investment committee, or whether that is allocated to the PIC? What are the distinguishing features that would require that the GEPF would take into account to make the investment directly? And in relation to that, does it also have investment limits and criteria in that regard? I know you come to the returns later, but perhaps for now.
Thanks, Commissioner. The investment committee does not currently have independent committee members. The committee members that are currently serving on the investment committee are trustees or alternate trustees. There is nothing that I think precludes the investment committee from having independence. As things stand, there is sufficient capacity within the investment committee, and I think that's part of the reason why there's been no need to bring external expertise, that there is sufficient expertise within the board and the investment committee. I need to say that there is, however, instances in other committees where expertise, where it's required, is brought into the investment committee. How big is the investment committee? I just want to check with my secretariat colleague, I think, just to get the number. 15, as currently stands. So that's that. And then in terms of are there direct investments by the GEPF and what's the criteria applied? Yes, there are very, very small investments that the GEPF has made directly. The intention is, by and large, to use the PIC as the principal investor. The reason for external use of investors was either in instances where the PIC at the time didn't have a mandate to invest on behalf of the GEPF. And it's also important for the GEPF itself to make some of these investments to be able to be in a position to engage and interrogate the PIC on the investments that it makes on its behalf. So by actually doing some of these investments, although they are small, it puts the GEPF in a position where it can actually also understand quite in detail how those investments are made, and to be able to actually engage and interrogate the PIC where it makes similar investments. I think that pretty much answers that, Commissioner. Are you okay?
Commissioner Marcus, may I just perhaps ask Mr. Sithole a question? The trustees, of course, are independent in the sense that although they are appointed to the Board of Trustees, they are not employees of the GEPF. Is that correct?
That is correct. Council, and I think this is quite important because I think it's important that people are represented on the GPF and they represent the different constituencies. So that I think is significant, and I think the law is designed in that way, and I think it is to be lauded for that particular reason. But it's also quite important to appreciate that once those trustees step into the board of the GPF, they no longer carry the mark of the constituency from which they come, because they have to act in concert as trustees jointly and serve the interest of the GPF, and more specifically to then of course extend that to say that they must serve the interest of all members, all pensioners and all beneficiaries, regardless of where and who those pensioners and members and beneficiaries must be. So it's quite important that once they become trustees, they no longer have any mark other than they are trustees of the GPF and work in the interest of the GPF.
Yeah, a question here. Yeah.
Thank you, Mr. Sutoni.
All right.
May I proceed, Chair?
Yeah. Perhaps since we are here, maybe we should deal with one big question which has arisen here. Labor trustees, on the board, on the IC, the investment committee, they participate in the investment policy and the strategy at the GPF, but they say they would also want to participate within the PIC because the PIC implements those decisions. What's your thinking about that, in a sense of that sort of double dipping?
I think that's a difficult question for me to have to answer. I can speak to the facts, but I think to speculate as to labor and how they want to do the things, that I think it's probably becomes very difficult.
It's a difficult question.
Yeah, it's a very difficult question, Commissioner. The fact is, and I think you've stated very clearly, Commissioner, it is that the labor is represented on the board of the GPF. And that is in terms of law and in terms of fact. So I don't think there's any contention as far as that is concerned. And the PIC Act does make provision for the minister in considering appointments to board members to the PIC depositors. And one of the major depositors, of course, is the GPF. And again, it's important that the fact that the minister, in terms of law, can consider nominations by depositors, of which GPF is one, does not put an obligation on the minister to then, of course, in any way accede to the recommendations that the GPF might make. And I think it's incumbent on the GPF then to decide whether it wants to nominate people to serve on the board of the PIC or not. Now, when Labour says they want to be represented, it is not an indication of the fact that they are not represented on the GPF board, or that through the GPF they would not have an opportunity to nominate a board member to the board of the PIC. I think that's pretty much all I can say.
So meaning you are saying that the GPF as a depositor would have to nominate labor reps onto the PIC if that was supposed to be the case?
Well,
is that what no, the GPF is
remember,
a depositor?
once a trustee comes to the board of the GPF, I no longer label them labor, so the GPF will then, from amongst its trustees, whoever they might be, and it may well be that one of the nominees is from labor, but in their nomination, they will not be informed whether the person is labor or employer. They will simply be nominating a trustee to serve on the board of the PIC.
Yes, so that could come from the depositors like a GPF,
yes.
But it could be the UIF also.
Yes.
It could be like the compensation fund.
Compensation fund, yes.
Yes, okay.
Yes, Commissioner.
All right, okay, thank you, thanks.
But you don't want to express an opinion as to whether it would be a good thing or not for labor to be represented, whilst represented on the GPF, be represented on the PIC board as well.
Well, I can express an opinion, but it is just that, an opinion. Okay? Governance is, and governance that represents as many constituencies as possible, I think is always to be lauded and to be accepted. So I don't think there is any reason for the GEPF to feel that labor should not be represented. However, in considering that, I think one needs to look at what currently exists. What does law really provide for? And as I've already responded, Commissioner, is that the law does provide for the GEPF, which has union representatives, to be able to nominate people to serve on the PIC board. So in a way, the law currently provides the scope for labor to be represented on the board of the PIC. Whether that happens in fact or not is not a reflection of the law, what the law provides. So that's the first point I would want to make. The second point is that, as I've indicated in terms of the GPF, once people step into an entity, say the board of the GPF, or in this instance, to answer the Commissioner's question, the board of the PIC, strictly speaking, where they come from becomes not really very important, because now they're expected to act in the best interest of that institution. And, well, we can never erase the fact that they come from a specific constituency, and therefore, intellectually, as they engage in issues, they'll probably always have that in the background, and one accepts that. But in fact, and I presume in law, they can't be representing in any other constituency while they're serving on the PIC board. So it becomes probably less important as to where do people come from on the board of the PIC. The important thing is, are they acting in the best interest of that entity? And that to me is much more significant than anything else. In a sense, and I think this might be probably pushing the needle further, I don't think it's too important who serves on the board of the PIC, provided they have the qualifications to execute the responsibilities that are entrusted on them. And of course, they diligently do so once they're actually serving on that entity. That's what I will say.
Could be a bad thing, could be a good thing.
Yes. I totally agree with you, Commissioner.
Yeah. Just to add there, so do you think, as I think Dr. Majila said, that board members at the PIC must go through the fit and proper test, Do you think that's necessary, to go through that, which is properly defined by the FSCA?
I think the answer is yes. I think fit and proper is a requirement for, I presume, most boards, not just the board of the PIC. So why would the PIC be dealt with differently?
Thank you. Yeah.
Thank you, Commissioner. Just to proceed, now I'm going to spend some time on the relationship as requested between the GEPF and the PIC. And again...
Sorry, Mr. Sitole, just to clarify one thing that I think would be important in relation to that discussion, is that the people, whoever serves on the PIC board, should not be the same people who serve on the Board of Trustees. If you're having labor representation on the PIC board, it should not be the same people who are on the Board of Trustees. They should be different. If you serve on the Board of Trustees and you're looking at the mandate and then you serve on the implementation as the same individuals?
Chair, I presume that the question probably relates to the potential conflict of interest that may arise. And I think that is correct, but it probably requires that we look at a number of things. The first, I think, if it happens, and it has happened in the past, and if my memory serves me well, I think it has happened with the recent appointment of the interim new board member, and the GPF is busy dealing with this reality. The law as it exists does make provision for depositors to nominate board members onto the board. So from a legal perspective, I think that the law does want a situation where depositors are involved in the management of the PIC. Now, the question is, okay, so that may be what the law says, but how do you deal with the conflict of interest? I think conflict of interest is probably something that we need to look at in relation to saying, we can't always say that the conflict of interest if people are put in a position where they are actually they're put there to serve the interests of whatever constituents they're representing. Because if one were to take that line and take it too far, it will be very unworkable in a sense, because nobody will ever be in a position to represent themselves or their constituents or their interests, because there will always be this charge of conflict of interest. So what's important is, so what is done to manage the conflict of interest? One of the things that I think the GEPF, if they haven't considered it in the past, will have to consider, because now they are members of the board that are presently have been appointed to the interim board, will be to say which areas within the management of the GEPF are those that are directly involved with the management of the PIC, and how does one create a distance between that and other processes. And my sense is that, for instance, one area that might have to be considered is the investment committee. To what extent can you have somebody serving on the investment committee of the GEPF as well as on the board of the PIC? That, I think, will have to be considered. But I don't think that that will then, of course, automatically extend to serving on the board of the GEPF, because there is the ability to recuse themselves if matters of investment are considered, because the board does not deal only with investments, it deals with a whole range of other matters. And therefore, the one area where if there's a potential conflict that those members that serve on the GEPF also serve on the PIC, will be where investment matters are being considered and discussed, and then those specific board members will then have to recuse themselves if that is appropriate. So the issue is about how do you manage the conflict. May I proceed?
You may proceed.
I think this is probably something that the Commission is already aware of, but I just want to reiterate a number of things before I really go to the statement. I think the GEPF and the PIC are very separate entities, and I think the PIC is a separate corporation. It has its own, well, it's a separate corporation with a shareholder which happens to be the state, but it is a corporation nonetheless. It has its own board, which governs the operations and the management of the PIC, and of course is responsible for all processes and procedures that are germane to the PIC. And one needs to appreciate that and separate it from the GEPF. It is also an asset manager, and I think that's also quite important. While it is owned by the state, it is an asset manager, pretty much like any other managers, and I think there's a question that comes later on around the legislation, the rules that govern the PIC, but I just wanted to make this point. Why? Because the relationship between the GEPF and the PIC is actually governed by an investment agreement, which was entered into between the GEPF and the PIC during 2007. This agreement governs the relationship between the parties. A copy of this is contained in bundle BSB1 of the bundle. Since 2007, there have been two addenda to the investment agreement. Copies of the addenda are contained in bundle BSB21 and B22. The investment agreement must be read with annex charts thereto. Specifically, relevant is the investment policy and the investment portfolio structure, risk parameters, benchmarks, and fees. Both annex charts are attached respectively as annex charts A1 and annex charts B3. I'm not a lawyer and will not attempt to interpret the investment agreement. In my respectful submission in terms are clear. Nonetheless, for the benefit of the Commission, I set out the more salient positions of the investment agreement here under. Some of the relevant positions are the identification of the legislation that govern the work relationship.
Sorry, Mr. Stoll. I'm just worried about what is happening somewhere in this building, and I don't know whether it interferes. I don't know if somebody's listening in as to whether the recording is caught up clearly. Is there somebody listening? Is it all right? Thank you. All right. I think we can proceed.
Mr. Commissioner, we have sent out somebody to attend to this.
The identification of the legislation that governs the work relationship between the GEPF and the PIC. They are namely the Securities Services Act. Again, it applies between any client and the asset manager in the country, so it's not really unique. Most of this is not really unique between the relationship between the GEPF and the PIC. The FASE Act, the Financial Institution Protection of Funds Act, number 28 of 2001, as amended, the PIC Act itself, and of course the GP law, the Public Finance Management Act number 1 of 1999 as amended, the rules of the JSE, SAFEX and Bond Exchange of South Africa, and any other licensed exchange upon which securities belonging to the GEPF may be traded from time to time, and all other legislation, rules, regulations, board notices applicable to the management of the investments in terms of the investment management agreement, whether in law or in terms of the rules of any relevant exchange. And I put the last one simply not in a sense to prevaricate or to avoid, is that of course any other law that applies to the PIC as an asset manager, similar to any other asset manager in the country, would apply to the PIC. The GP law prescribes that the board must consult the Minister of Finance on any changes to the investment policy. Now, this is quite important because this is where, and probably the one instance where the board has to, in a sense, engage with government. And it is with respect to the investment policy and any changes or amendments thereof. The board cannot unilaterally make any changes to the investment policy, but it also means that the minister cannot make unilateral changes to the investment policy either. So it has to be a joint consultation between the parties.
Does and has such consultations taken place, and do they take place on a regular basis, or only as, or two different questions, a GEPF interaction with the minister on a regular basis, or the board of trustees with the minister, and a consultation with the minister about any changes to investment policy? Have there been such discussions? Do they take place regularly?
Commissioner, the answer is yes. There are two kinds of consultations. I think they are the ad hoc as and when there are matters that needs to be considered. But there is formal consultation when there needs to be a fundamental change to the investment policy. The one relates to, and it's currently underway, is where the GPF from time to time looks at the overall investment structure of the GPF and specifically does an asset liability modeling to make sure that the investments are made in such a way that they respond to the benefit promises that have been made to members, pensioners, and beneficiaries. Otherwise, we call those liabilities. Now, there's a whole process that is done, and is done with the advice, and I'm going to come back to later in the statement, with the assistance of properly qualified professionals to arrive at what should the strategic asset allocation of the GPF be. Now, once the professionals have gone through the process with management, that gets presented to the investment committee, and from the investment committee to the board. And once the board is satisfied and has taken a view, then it is submitted to the minister, and then there is an engagement between the GPF and the minister. And only after that process has taken place is either the existing strategic asset allocation continued with, or amended in terms of whatever the agreement has been with the minister. So the long and short is that there is such engagement. And of course, there's also ad hoc engagements as when there are changes to the mandate that then would actually entail an interaction with the minister.
And you've had no difficulty having those meetings?
That's a difficult one to answer. There have been difficulties, but those difficulties I don't think have been due to the lack of interest from both parties. One of the challenges that we've had in recent times has been, I'm sorry to say, the changes in the minister. So you engage with one minister, and a few months down the line, you have to start all over with another minister. And I think we've had difficulties getting finality simply because there hasn't really been consistency in the ministry. And that has been, I think, the biggest contributor to the fact of having challenges in getting the agreement. But ordinarily, there aren't any challenges. The GPF granted the PIC a power of attorney in accordance with Annex C to the investment management agreement, and appointed the PIC as an investment manager with the authority to act as its agent in managing and administering the portfolio within the constraints specified in the investment management agreement, and specifically Annex A and B to the investment management agreement, and subject to any policies of the GPF which are appended in the investment management agreement. By accepting the appointment referred to in clause 3.1 of the investment management agreement, the PIC acknowledged its duty and responsibility to administer and to manage the portfolio as a fiduciary in the utmost good faith and with due care, diligence, and skill, which is to be expected of any expert investment manager, and generally its duty to act in accordance with the terms of the investment management agreement at all times. The PIC, unless otherwise agreed in writing, acts as the GPF's agent, and the GPF will be bound by the PIC's actions under the investment management agreement. The investment policy of the GPF, developed in consultation with the Minister of Finance.
Yeah.
Sorry, Commissioner, I didn't see your hand up.
Yes, a question here on 7.4.4. All right, let's go back there. What happens if the PIC, for some reason, loses a lot of money, say 20 billion rand, 30 billion rand, due to no care, no duty to care or something like that? Would the GPF sue the PIC? Because if it does that, then the PIC will go bankrupt. If the PIC had to be sued for 20 billion, it don't have the money to pay that cost.
Well, I mean, any entity that takes action to protect its right, not to protect the rights of the entity against which it's acting. So I don't think in the first instance the GPF will concern necessarily about the existence of the PIC. It will have to deal with the facts. But I think I need to answer the question slightly much more broadly. Your question is about losses, and I think we need to be clear that the investment managers make bona fide losses. No investment manager can always guarantee you that the decisions that they make will always be correct and they will always pan out. And this is not unique to the PIC. So the fact that in investments money will be lost is part of the nature of investment and taking risk. And to the extent that the PIC takes decisions and bona fide loses money because it is not a profit, it can't see into the future, it makes decisions based on the information that they have, and that information may be correct or not correct, or it may change as life changes into the future. To the extent that that is the case, those losses, we don't want them, and we wish we didn't have to have them, but they are part and parcel of investment, and I think that's one thing. However, where there is negligence, and I think negligence has to be demonstrated and proved, and I presume not just by Able Sithole or the GPF, but it has to be negligence that probably will stand in a court of law. And if there is such negligence, the GPF, I think, will reserve its right to take action. And it will take action not necessarily concerning itself about whether the PIC as an asset manager will survive or not, because and I think this might be a strange statement to make. What's important to the GPF is not necessarily whether the PIC survives or not. It's that it actually executes the mandate in terms of the undertaking that it has made in accepting the investment management agreement. And of course, PIC is not the only asset manager around. There are other asset managers, and there are things, of course, that the GPF itself can do to manage its own assets. So the fundamental thing that will inform the GPF's action will not be whether the PIC will survive or not the action. That I think will not be quite important. I think it will be a consideration, but I don't think it will be a major consideration.
All right, thank you.
The PIC, unless otherwise agreed in writing, I've already, I think, highlighted that. The investment policy of the GPF, I think I was in that process. The investment may be amended from time to time by the board of trustees of the GPF after consultation with the minister. I think I've made this point earlier. The PIC warranted in the investment management with that it shall at all times comply with the common law of agency, the provisions of the Fires Act and of the Financial Institutions Act number 28 of 2001, as well as other applicable legislation that the asset of the GPF administered in terms of the investment manager agreement will be owned solely by the GPF and shall constitute trust property as defined in Act 28 of 2001, that's the Trust Act. All the PIC's dealings on behalf of the GPF will be conducted in accordance with the terms of this agreement and on an arm's length basis in the open market. The GPF further has a developmental investment policy, a copy of which is attached under Annex A2. The policy statement refers to investments that deliver both financial and social returns. The GPF allocates 5% of the total portfolio for the developmental investments. Through developmental investments, the GPF plays an important role in addressing many of the pressing economic, social, and environmental challenges such as growth, unemployment, and inequality. Some of the important principles that we recognize are the following.
Sorry, before you move there, the 5% is of the total of the GPF funds.
That's correct,
That's
Commissioner.
of the 2 trillion.
Of the about 2 trillion, 1.8 trillion. Yeah. Yes, Commissioner.
And that 5%, is that committed capital or is it invested capital? Because sometimes there's that confusion.
Commissioner, there are three things. So one is that in terms of the GPF strategic asset allocation, and I'm going to use the word to commit, but it's going to confuse the second commit, so I need to find a better word. So what the GPF does in terms of the strategic asset allocation, it ring fences up to 5% of the portfolio for potential investment in the space, in the developmental space. It's not committed, it's purely an undertaking. It's simply saying that in terms of my promises to my members, I can tolerate up to 5% being invested in this particular environment. It's not a commitment, it's purely an undertaking that the GPF has within itself. And then it allocates monies now specifically. And that's where there is money that we commit, and then there is money from the committed amount that are then invested. And therefore there's a distinction. So it doesn't necessarily mean that the committed amounts are equivalent to the 5%. In all instances, the committed amount are actually less. And even more so, the invested amounts are even also less. So they're not really the same thing. They are very different categories of things.
So the 5% actually is within the GPF
strategic asset allocation.
It's in their own thinking, and then the others are much lesser than that.
Yes.
Okay. All right.
That investment capital can and should be put to use for the pursuit. First, of course, because we are a pension fund and we are concerned about the interest of our members. Both those are still in service, the active members, and of course the pensioners and their beneficiaries. So the first target, the first mandate is to achieve financial returns. And then, of course, over and above that, to address any other social returns that we would like to realize in terms of our mandate. That sound investments can be combined with socially benefits. So again, it's simply to state that we do not believe that focusing on social returns necessarily abrogates the responsibility to achieve financial returns, that the two can be done simultaneously. That good financial returns for members and pensioners can be made while helping to make South Africa more competitive, reducing social backlogs, making the economy more sustainable, creating jobs and supporting transformation. That developmental investments provide large-scale and long-term investments opportunities which are well suited to the needs of the GEPF as a large investor with long-term liabilities. That developmental investment enhances the sustainability of returns in the long term, which is in the long-term interest of the GEPF's members, pensioners, and their families or beneficiaries, as we state in law.
So if one had to just put it succinctly, it would be that socially responsible development is part and parcel of the mandate, but not at the expense of returns.
That is correct, Commissioner. That is correct.
Differentiated returns, yes, but not returns.
But not contrary to. Yeah. And I think there's more work that's being done in this space that indicates that the two are not necessarily mutually exclusive, that actually you can achieve both. And actually, when you think in terms of sustainability, the more you combine them, the more sustainable in the long term they are. As part of the oversight duties, the Board of Trustees commissioned a legal opinion on the relationship between the GEPF and the PIC. The legal opinion primarily confirmed the above principles set out in the Investment Management Agreement and common law rights. A copy of the legal opinion is available as Annexure B4.
A question here. Before we leave this section, I've got two big questions which have been asked. Just in terms of the mandating process, we had COSATU here and some group called AMA-GP. And they said that, you know, what happens to the GPF when, let's say, the PIC is burning and there are huge problems? Is there a way in which the GPF can intervene within the PIC over and above the investment mandate? Is there some way in which they can, as a first question? The second one is on those groupings felt that they contacted the GPF to raise concerns about the investments, but they were not listened to, you know. So, I mean, how would stakeholders like those manage to find a way to talk to the PIC or the GPF? Those are the two questions.
Commissioner, they sound simple questions, but they're actually quite quite difficult and questions. Okay, let me. But the answers are not very difficult. I'm going to paraphrase your question. So if I'm not doing it correctly, Commissioner, you must correct me. So the question is, how does the GPF intervene in instances where the PIC does not act in terms of mandate? I think that's the first question. The answer to that is that, and again, one needs to appreciate the way the relationship between the GPF and the PIC is managed. And I think I'm going to kind of invert the process. There is engagement between GPF executive and GPF executive and PIC executive on a regular basis, on scheduled regular engagements, meetings that take place, some of them monthly, some of them take place quarterly, some of them take place as and when there are issues that must be engaged between the parties to try to ensure that the assets of the GPF are managed properly. And of course, from that, there's reporting to the investment committee of the GPF, and from the investment committee of the GPF, there's reporting to the board. So there is constant oversight that is taking place and engagement. So the first point of call is not how do we punish, it's how do we remedy or fix things before they become problematic. And that actually happens through engagement that is much more regular than I think it may be appreciated by people who are not involved in the GPF. I will presume as well, although I can't say more than as an outside party, there are processes within the PIC itself in terms of how those things are dealt with. But from the GPF process, it's constant engagement, either ad hoc or on a regular basis, that ensures that the GPF holds the PIC to account in terms of how it manages its monies. Now, the first thing is, of course, is not punishment, it's remedy. So how do we remedy? And that speaks to remedy, that there are processes to remedy when things are not going as they should, and that's happening all the time. The second part of that is that, okay, so if something goes terribly wrong, what could be done? I know that the Commission is busy looking at the potential of wrongdoing, and I don't think it's the only thing that the Commission is looking at. There's a whole range of issues that you're looking at, but it may well be that one of the outcome of this Commission is to establish some kind of wrongdoing. I can say that there has not been to date an instance where there was deliberate negligent wrongdoing that would have prompted the GPF to act, and therefore the GPF has never had to take sanction. But that's not preclude the possibility of sanction. I mean, one of the sanctions that I think the GPF has is that the PIC is a manager. While people believe that there is this unbroken umbilical cord between the two organizations, in law there is no such, that the GPF can look for other avenues to manage its assets to the extent that it believes it's correct to do so, and it makes sense in terms of how it's going to manage its assets into the future. So I think that's quite important to state that is always there. I'm not saying it will be an easy process. I think it will be a difficult process, but that in law is a potential sanction should that happen. I do also want to say one needs to look broadly in terms of saying, do things go wrong, and how does one deal with that? Or more specifically, how does the GPF deal with any potential wrongdoing? The GPF is, as has been stated, is close to 2 trillion, 1.8 trillion in size. A significant part of that 1.8 trillion, and then if I can use an example, about 70% of that is managed conservatively. Basically, it's traded either on the JSC, on SAFEX, on the bond exchange. It's dealt with in the open market, and the potential for any shenanigans or things going wrong there, it's either ordinary wrong decision making, which it's not likely to be, for instance, because in the bulk of the portfolio, we do what's called index tracking. We simply follow the index. Yes, we have to given our size, do that over a period of time, but it's really just following an index tracker. So the issue there that might arise is whether you're paying your brokers a fair fee or not. But fundamentally, there's no issues there. Then, of course, there are other mandates. There is a chunk of assets managed by external managers through mandates. That does not necessarily become part of what the PIC decides itself. It is decisions taken by other managers. You might question how those are appointed, but that's a completely different question. Then there are investments in other assets like property, which are physical assets. You can question that. So we always need to say that the area of potential where things can go wrong within the GEPF is actually much smaller, if I can venture to say, than what I think people think. I think the number that I have in my head is just slightly below 5%. The bulk of the assets are managed in a manner that gives the GPF confidence that there is very, very little scope for things being untoward in that space.
Yeah. So just on the first point, so you are saying then the worst that the GPF can do to the PIC is to extract these assets.
Extract the mandate.
That's the worst it can do, yeah.
It's not the only. I think and there has been such action. For instance, when it became very clear that there might be concerns around how the PIC might have dealt with some of the investments, especially in the unlisted environment, certain actions were taken by the GPF to try to manage and to constrain what the PIC could do. So one of the first things that we did was to provide a limit on the investments, because up until that time, the PIC has and still has a discretionary mandate. But in the unlisted space, the board took a decision to put a limit on the discretion, a 2 billion limit on the discretion, to say if you are investing in unlisted beyond 2 billion, we're not saying you can't, but if you do, you need to come to the GPF and involve the GPF in the process, and in a sense, get our GPF approval. But actually, we don't give approval. We simply interrogate and then go back and ask questions of the PIC and make comments and still allow the PIC to continue going forward. So that is an action which the GPF, for instance, can take, where it places a limit to say, I'm going to actually limit the discretion of what you can do. So it's not just about just withdrawing the mandate. There are other actions that you can take.
The second question is about AMA-GP and COSATU and stakeholders. How do they get listened to by the GPF or the PIC? And these could be indirect stakeholders even, you know.
All right. Well, number one, I think, as I've indicated, the law would actually preclude such direct involvement of any external parties in the investment process, because the law quite specific. It should be a process that involves both the GPF and the minister and no external parties. So that I'm talking in terms of law. But of course, the GPF is there to serve the interests of members and pensioners who are represented by stakeholders, and there is engagement with those stakeholders. I'm not sure about the COSATU making that direct statement, but I know that AMA-GPF has made that statement to the Commission. I would like to state that the following. And I'm sure, and I am sure that in the very statement that the AMA-GPA made to the Commission, they said the following. They said that they have challenges with engagement with the GPF. However, when they engage the GPF, one gentleman by the name of Abel Sitole lectures to them. Now, if you're saying somebody's not talking to me but they're lecturing to me, that's a contradiction in terms. So just off the bat, I think that in the statement itself, there's a contradiction. You can't say that I'm speaking to this person is not speaking to me, but they're lecturing to me. By definition, it means that there is a conversation that's going on. So that's the first point I want to make. The second point is, and I don't have the proof, but if the Commission wants, I can provide such. I can provide proof that probably within a month of them making that statement before, there had been engagement between me and either one or two of their members. So I can categorically say that statement is not correct. I think there's been a lot of engagement with MAGPA in terms of them coming to our office, us speaking to them about all kinds of manner of issues that they raised. And there is actually email conversation that I can demonstrate to the Commission that that statement can be correct, even after the fact, not informed by the conversation with their representation to the Commission, simply because they are a stakeholder, and I think it will be very untoward for the GEPF not to engage them. But if they're saying, I think the statement to me can be shown not to be quite accurate. I do want to make a point, though, to say that, and at the beginning I indicated that the nature of the GEPF is such that members must appreciate, that means pensioners, active members, beneficiaries must appreciate that investments, contributions have absolutely no impact on the benefit that they get. I'm not saying they shouldn't be involved. I'm not saying they shouldn't be concerned. I'm not saying they shouldn't be asking questions. But to ask questions as if those decisions impact, and actually go publicly and speak as if these investments impact the benefits of members, I think it's inaccurate. And actually it's very dangerous because it misinforms members and pensioners. And then pensioners actually become anxious and they worry when in actual fact it does not at all impact on what they get. As I stated in the beginning, there really are three things that dictate what members get as benefits. Years of service, your salary average of the last 24 months for good reason, and an accrual rate that is in the GP law. That's all that matters. So when people then actually start to saying, but this is affecting our benefit, I think that is not correct. Well, I don't think, I know it is not correct. So I think the engagement that members, whoever they might be, have with the GEPF or with the PIC must start with the appreciation of this fact. It is important to the GEPF to ensure that the assets are managed prudently, properly. That is the task of the GEPF board, and by definition, the delegation to management. That is their job. That is what I have to worry about, and my colleagues have to worry about every day to ensure that these assets are managed prudently and they give the return, because that is the basis on which benefit can be paid. If we don't do so, of course, in terms of GP law, as I indicated at the beginning, it means we might then have to go back to the government to ask for the government to then fill in any hole that has been created by our lack of acting in a prudent manner to protect the investment of the GEPF. Therefore, it is, of course, an important matter for the Minister of Finance and for government to ensure that the GEPF and the PIC are managing those assets properly, because if we don't do so, we'll then have go to government to ask for them to live up to the guarantee that they're provided in terms of law. Now, I sometimes struggle to understand why people would assume that the government would kind of willy-nilly not understand that obligation, because it's an obligation in law. So when GPAA say they are engaging with us and we're not responding, I'm not sure the issue is whether they're engaging with us or not responding. I think it may be that they're not happy with the answers. And one of the answers that they're not happy with is when I tell them, and the GPF responds, yes, we respect your interest in the GPF and its management, but you must not in any way misconstrue, misinform members by saying that that has direct impact on their benefits, because it doesn't. Now, that statement is always true, and it doesn't matter how much they ask and what they want, that statement will always be true, until such time that something else happened, and it hasn't happened so far.
Yeah, I need to follow up this. So, technically, you are very correct about that. But then people see salaries, see contributions coming out of their salaries, and wherever you go, whether my relatives or going to the townships, to the suburbs, they say that our monies are being misspent and we are worried about our pensions. And I agree with you that they actually shouldn't be, because that's a different process altogether. But then that means that the stakeholder management and the stakeholder communication could be a problem if people are saying different things to what is a reality, you know.
Commissioner, I think you're right. I can never say that our communication is perfect. And I think the board will acknowledge that. I think communication is something that we have to improve. We take cognizance of that, and we are seeking to improve our communication all the time. So that I acknowledge, and the GPF will acknowledge it any time. But we also need to guard against the other side of things, is where certain stakeholders, because they are well organized and they are well resourced, want to actually start to have undue influence on how entities are managed, because there is that also reality that when people start to behave as if now they are, it's like me starting to behave as if I can manage the assets that the PIC manages better than the PIC can. Well, I'm not an asset manager, I'm a pension manager. If I think I can be an asset manager, I should go and sit on the other side and be an investment manager. And therefore, in my engagement with the PIC, I still need to take cognizance of the fact that I have a different role from the one that the PIC has. And I think some stakeholders sometimes want to go beyond that boundary, where they start to almost think that for some reason they have better knowledge, better capability in terms of how the assets of the GPF must be managed. I'm not sure that's always informed by an interest that covers all membership, which is the task of the board, to look at the interest of all members, all pensioners, all beneficiaries, not for some small interests that some party wants to protect, if that is the case.
Finally, so you are saying that, you know that people sometimes confuse the PIC and the GEPF, and then they would say the PIC is wasting our money and we are scared, we want to resign from work and cash out our pensions or whatever. And so who must do the education drive to ensure that people actually are well versed with these matters?
In the first instance,
they're not fearful, they are calm about these issues and they're not fearful and all that.
Okay, and I hope, Commissioner, that you don't get cross with me. I'm going to reiterate this point. The benefits of members do not depend on investments. The benefits of members do not depend on contribution. So, as a matter of fact, yes, they can ask questions about how their assets are being managed, but you must make a distinction between that and how it affects what they ultimately are entitled to in terms of benefits. And I reiterate, that has nothing to do with the investments. However, it does not say that they mustn't ask the question and we mustn't respond to it. And the responsibility, to now go to your second part of your question, in the first instance, it's the GPF, and I think we accept that responsibility, and in the past, we might have not done it very well, and currently, I can't say it is the best that we can do better, and I think we will want to actually constantly improve and do better. So it is us. But there are other stakeholders that are involved, and we as the GPF are taking the responsibility to actually engage with those stakeholders to ensure that members are better informed. In the first instance, the point of first interaction between the GPF and the member is at the time of employment. So when the member signs in and then their contributions are pledged to be contributed to the GPF, at that point in time, that should be a point of making sure the member understands what that money that they're going to have deducted from their salary will be channeled to the GPF, invested. So that then puts a responsibility on the employer to actually communicate in terms of money is going to be deducted from your salary, but where is it going to, what is it going to do? So I think that's one point of call. And of course, as the GPF, we need to empower the employer to be able to do so. So that's one area. And then the other one is, of course, other parties, stakeholders. For instance, labor unions have a major interest in us communicating to members. And I must say that as we speak, that actually is something that is starting to work and work very better. We're starting to run workshops with the PSCBC where we deal with matters that are of concern to members and when that is required. So to the extent that in the past we haven't done it, I can categorically say we are now doing it. Is it the best that we can do? I doubt that it can, and we seek to improve all the time to ensure that stakeholders understand these matters. But Commissioner, I think some people deliberately want to sidestep the facts and simply want to impose themselves on processes when I don't think it's appropriate.
Thank you. Thank you.
Mr. Sithole, just a small question. When Dr. Machila was giving evidence last week, he said that the regular meetings between the GEPF and the PIC did not happen as frequently or as effectively as they could. You've indicated that you think these are adequate. Can they be improved? Are they held on a regular basis? As you've said, scheduled. He also said scheduled, but sometimes not happening even though scheduled. He did not attribute it to either the GPF or the PIC, but to both as availabilities, etc. Your comments?
It's a difficult question, and I would ordinarily steer away from pointing fingers, but I think this is, again, it's a fact that can be proven, is that in instances where meetings have not taken place as they were intended to, I'm quite sure that it wasn't because the GEPF sought to reschedule those meetings. And that, I think I can provide the proof that that is the case, that we, as the GPF, are by and large quite available for meetings that are scheduled. So if Dr. Dan spoke at meetings that didn't take place, I can categorically say that in all probability it was because they didn't avail themselves to have those meetings. But the more fundamental question that you're asking me, Commissioner, is could more be done? Again, I think the answer is, to the extent that I think one wants to have much more rigorous monitoring, evaluation, engagement, of course we can. But I don't think that that is due to the fact that the current scheduled meetings are in any way inadequate.
Current scheduled meetings not inadequate, given that they take place as required, or that the scheduling is correct and that all we need to do is make sure it's implemented effectively with the rigor that's required?
That there are scheduled meetings, they need to take place when they are meant to take place. And of course, there will always be the need for ad hoc meetings.
Sure.
But that is neither here. The scheduled meetings, to me, are quite sufficient. If the parties respond and provide each other with the requisite information to engage on the matters in time to be able to engage properly, then we wouldn't have no challenge with the current scheduled meetings.
Thank you.
Commissioner, may I proceed?
You know, I've been listening, and I'm just wondering how you communicate with the organization that calls itself the AMA-GP. Do you know if they hold meetings, and if so, do you ask for a slot maybe to speak to their membership rather than speaking to just one or two people?
Well, I think there is an institution called AMA-GPA. I think they have themselves indicated to this commission that they represent no more than 500 members. So that's quite important. And why? Because the GPF has 1.2 million members, active members, represented by labor, by unions. So anybody that comes to me and says, I represent all membership, I think is not telling the truth, because, I mean, most of the GPF's membership has representatives, and more specifically in terms of engagement, that takes place through the Public Service Coordinating Bargaining, the PSCBC, and that takes place regularly. And the question that you've asked me, Commissioner, does happen. We appear before the Commission, the Council, not the Commission, the Council, and we've asked for regular slots, and there is engagement on a regular basis. So that's with regard to active members. Therefore, AMA-GPF can't claim to represent that constituency because it is properly represented. Then, of course, there's pensioners. In the first instance, I think the representation, as is true of active members, they have a representation on the board in terms of a pensioner representative. Now, it's important, and I think I was asked to comment on this earlier in the beginning. Pensioner representative, there's a full trustee and an alternate or substitute, are elected by pensioners themselves through a very open process, nomination and then election. And AMA-GPA has the ability, if they want to actually be represented, to put a candidate and then to make sure that candidate succeeds. To the extent they do that and the candidate fails, they can't then blame the process for not giving them a place on the table, because they tried and somebody else was elected, and they shouldn't try, once they failed in that process, to find a backdoor way to make their voice heard. So that's the first point I want to make. However, 500 people are a significant constituent of the GPF. So the GPF can't ignore a group of people that represent 500 pensioners. So we, and I think they've attested to this in their presentation to the Commission, that there have been meetings with them, with the GPF. There have been instances where they invited the GPF to speak at the annual general meetings. We've provided resources to go and do such. They've interacted in a combined meetings between the GPF and the PIC. So when they say we're not meeting them, I don't think it's a question of fact. I think it's a question of either they want more regular meetings. Now, what does that mean? Or they don't like the content of what they are being told because it doesn't suit whatever they might want to. Now, I can't answer to that. But to say that the GPF somehow doesn't interact with them, I think can be factually be demonstrated not to be correct.
Yes, thank you.
Thank you, Chair. Unlisted investments fall within the investment agreement. In 2009, the GPF commissioned an advisory and financial analyst firm to conduct an asset liability addendum to the investment management agreement was entered into, a copy which is attached as Annexure B21. In terms thereof, the GPF and the PIC agreed to implement the new unlisted investment model. In terms thereof, the GPF approved the private placement memoranda, otherwise called PPMs, in respect of the South African Private Equity 1, Environmental Infrastructure 1, and Priority Sectors Fund 1. Now, that's purely a categorization of different funds in the unlisted environment, but all of them literally just fall under the rubric of unlisted investments.
Question here. Just in terms of 10.3, what would the legacy be? I mean, would the AfriSem and the others fall within that part, or
That is correct, Chair. Investments like AfriSem fall under the legacy. So this actually referred to the ISBAYA that was set up before the board was proper. I think this goes back to 2006, Adri, when there was no proper investment agreement on the investments of the unlisted environment. But the AfriSems definitely fall under the legacy funds.
And the 12 or 13 billion like invested there would be very different to
the new one.
To the new one, because there were limits there.
There are much more constraints and risk parameters that have been set for the second part of the ISBAYA
then
fund.
within the non-legacy portions.
Yes.
Yeah. Okay.
Correct, Commissioner. The management of the governance of the funds will be in line with the private equity industry's best practice. So again, the fact that it is unlisted does not necessarily mean that we do something esoteric that is outside of what is being done by other players in the market, that the intention should always be to follow best practice. The PIC has the ultimate responsibility of managing and controlling the business of the funds, but where appropriate may, and in its discretion, delegate certain responsibilities to other independent service providers to implement the objectives and administer and manage the assets of the funds. Now that's quite important, because there's an assumption that the PIC is the sole, even within the PIC, manager of unlisted assets, and that's not true. There are assets that have been given by the PIC to other private equity entities that are managing funds in the unlisted environment outside of the PIC itself. So I think it's important to make that point.
Just how big is that portion of assets which are not within the PIC in the unlisted space?
Commissioner, I don't have the numbers right now. Let me just ask, my colleague might have a number, but if we don't have the number, we'll come back to the Commission to provide the answer. Okay, my colleague is not comfortable to give a okay. Rough number. We will provide the Commissioner with the number.
Yes, please do, please do,
The most recent asset liability modeling was done in 2016, which generated a proposed optimal strategic allocation. The GPF is currently awaiting the Minister of Finance recommendation in this regard. During October 2016, the second...
Sorry, Mr. Sotole. If if that was done in 2016, it's roughly 3 years ago.
Yeah.
How, given the changing climate domestically, globally, is that still appropriate, or would it need review before it gets approved? What is the process going forward, given the time lapse?
Commissioner, of course, 3 years is a long time under ordinary time, but under the GPF, it is a long time, but it's also not a long time. I think the GPF is a long-term investor. So I think ideally, once a decision is made, one wants to have it considered and implemented as soon as possible. So preferably, I think we shouldn't be where we currently are, but circumstances are such that we find ourselves here. So the question is, to what extent are we worried of by the delay? Yes, we are concerned because it is a delay, but it does not fundamentally in the long term change the strategic asset allocation of the GEPF to the extent that we would almost start, for lack of a better word, panicking. We are concerned, but we are not panicking. So to answer the question more directly is that would that then warrant us to go back and review the work that was done by the consultancy and of course agreed to by the board? The answer is it would probably not be necessary to do so. I think the strategic allocation as it stands, given its long-term nature, will still be sufficient.
Would there have been consequences in implementation in terms of better choices if you had an earlier agreement on it? Because 3 years, I understand long-term investment, but 3 years is a long time if you say we would like to do the following, conditions change, circumstances change, opportunities change. If investments had taken place if there had been a more timeous approval.
I think that the honest answer, because it could be, things could go either way. So I think the honest answer is that there are material consequences to the delay. Now, whether they are material positive or negative, you'll have to assess that. But the answer is there are material consequences, yes. As I was indicating, during October 2016, the second addendum to the investment management agreement was entered into. A copy is attached as Annexure B22. In terms thereof, the PIC undertook a process in terms of which a second fund, the Isibaya private placement memoranda, was raised from the GEPF. The GEPF and the PIC agreed that the following sub-funds would constitute this fund. The Private Equity South African Fund 2, the Rest of Africa Private Equity Fund 2, the Rest of Africa Development Investments Fund 1, the Energy Infrastructure Fund 1, the Environmental Infrastructure Energy Fund 2, the Economic Infrastructure Fund 2, the Social Infrastructure Fund 1, the Priority Sectors Investment Fund 2, and the Small and Medium Enterprises Fund 2. Now, of course, it's a long list, but these are targeted at very specific areas where between the GPF, we think there is a need for both the GPF to diversify its investments and more specifically where we think the economy requires some injection of capital, which of course it is expected that the GPF will get a return. Pursuant to a detailed due diligence exercise, the GPF approved the total capital commitment to the Isibaya PPM Fund 2 in the amount of 70 billion. The funds are invested for actually, they're not really invested. They are determined to be invested because not all of that 70 billion has actually to date been invested, and actually a small portion has been targeted to be invested for a period of anywhere between 10 and 15 years with a commitment period of 5 years. On October 26, 2017, a letter was sent by the GPF to the PIC stating that the Board of Trustees of the GPF resolved the following with regards to the PIC's investment limits in unlisted investments. The PIC is required to seek approval from the GPF for any single investment above 2 billion for unlisted and properly investments. Unlisted investments above 2 billion limit must be submitted to the GPF board via the GPF's investment committee. The following principal terms regarding investment limits of the PPMs, which were approved in 2016, are still applicable. A maximum of 30% of aggregate capital commitments for each sub-fund in any single investment. obligor, obliger, maximum 30% of aggregate capital investments commitments for each of the sub-funds in any single counterparty, sponsor, or obliger. Now, that's quite important. That's part of the risk management in terms of what's been placed on how the new money must be invested going forward.
Sorry?
Okay, you can go, Jay.
How would you deal with cumulative investment? Because if you've got 2 billion for each single entity and they've got different names but belong to the same group, there's quite a few that have come up in the testimonies here that amount to significant amounts, around 8, 10 billion per group, so with big risks. How does this 2 billion apply in relation to that in reporting entity? Because it can be just below the 2 billion for each of those investments, but the cumulative total is way above the exposure to the group. Have you looked at that and what implications from that?
Commissioner, initially, I think the limit was put bona fides. I think the assumption was that it would be inclusive, that it was 2 billion in real terms. So that's how it was taken. But subsequently, the board has now gone back and addressed that point to say, and it has actually gone slightly beyond that to say, number one, it's to address the matter of cumulative investments, and number two, to not only say that we should look at investments above 2 billion in totality, but it is 2 billion to the extent that whatever cent of the GPF is used in that 2 billion, because that's another way that one can get around that, where you say, okay, we will use $1 billion from the GPF, and therefore we don't have to go to speak to the GPF, and we can go to the other investors and combine the two to make it 2 billion. Now the GPF has gone to the PIC to say it doesn't matter how much money of the GPF is being put, to the extent that investment in totality is beyond 2 billion, and we investing some of the GPF money, the GPF wants to be involved in that process. But it wasn't envisaged as such at the beginning, because the assumption was that that would be concluded to be part of the process.
Would you consider that a breach of faith?
A breach of faith, yes, not necessarily a breach of law.
No, but it's a breach of faith and trust.
Yes.
Next one, on 10.7.3.2, you are saying this is limited to 30% of the sponsor in aggregate, but can a sponsor get money from the various sub-funds that, the PIC runs? So they will tap into the 9 funds which you have, and you cannot restrict them from doing that.
No, that's not the intention. The categories, so each of the categories under 10.5, that is supposed to be quite ring-fenced, and to the extent that the PIC wants to move between them, I think they will have to come and engage the GPF with that regard. So the idea is to ring-fence it so that you don't then use funds from different subcategories of investments. That if you, for instance, are talking about investment in energy infrastructure, it must be confined to energy investment.
Yes, but can a sponsor ask for money from various funds, say 4 or 5 funds, and say those are separate funds and those are separate investments and all that?
No, that shouldn't be. They should be able to ask, because remember, the idea is to invest in projects. So if you're building a solar plant,
yes,
you can only ask money for that solar plant or for that one wind farm from the energy infrastructure.
Yes.
Now what you're saying is, okay, but somebody could say, but that's also a small medium enterprise. Now I also want to get some money from the small medium enterprise. I think that's what you're really saying.
Yeah.
No, they shouldn't be able to do
and
that.
And also I'm saying that if someone says, I'm in this fund, I've gotten the money there, but I got another sort of project in the health sector, which is in the social.
Oh, okay. No, I misunderstood that, Commissioner.
Yes, yes.
How the answer is, strictly speaking, the answer should be yes. If you are involved in an energy fund in the Northern Cape, and then you're involved in a health, or in a clean energy project in the Northern Cape and you're involved in a health project in Mpumalanga,
Yes.
those are separate entities and you should be able to be funded for those two separate entities, yes.
All right, so meaning a sponsor then can get anything, can get 10 billion, from the PIC without any
Again,
problem?
in practice, I'm not sure that it will be easy to justify that you can be all things. So in terms of due diligence, I doubt that one could make that case successfully.
Yeah.
But in theory, the answer is
In
yes.
theory, yes,
Yes.
that you can.
Mr. Chairperson, it may be of assistance. The letter which is referred to in the statement of the 26th of October is to be found in a bundle A3 at page 46. Perhaps I can refer you to that, Mr. Sithole. It's your letter, and perhaps you could just read into the record paragraph 1, page 46. I'll hand you mine if you want.
Chair, this is a letter addressed to the PIC through its CEO, Dr. Dan. The Board of Trustees of the GEPF resolved the following on 20 October 2017 with regards to the PIC investment limits in unlisted investments. 1, the PIC is required to seek approval from the GEPF for any single investment above 2 billion for unlisted and property investments. Investments above 2 billion limit must be submitted to the GEPF board via the GEPF's investment committee for approval. The following principal terms regarding investment limits on the private placement memorandums, PPMs, which were approved in 2016 are applicable. A maximum of 30% of aggregate capital investment commitments for each sub-fund in any single investment. Single obliger, maximum 30% of aggregate capital for each sub-fund in any single counterparty, sponsor or obliger. Now that's the point where you're double dipping and you're splitting of investments. That's where the risk is being managed. Notwithstanding these terms, any single investment above 2 billion is subject to the approval by the GEPF. This resolution revokes any previous investment limit set by the GEPF Board of Trustees for the PIC with regards to the investments in the GEPF's unlisted and property investment portfolios.
Thanks.
Can I perhaps just ask a question here before I forget about this? I just want to make it very clear, Mr. Sithole, that the sentence, notwithstanding these terms, any single investment above the 2 billion is subject to the approval by the GEPF. That only refers
To unlisted.
Unlisted and property.
Yes.
Thank you.
Yes, that's correct, Commissioner. Just where am I now? I think I was
10.8, you're on
10.8. The above resolution revoked any previous investment limit set by the GEPF Board of Trustees for the PIC with regards to investments in the GEPF's unlisted and property investment portfolios. A copy of the above letter is attached as Annexure A3. That's the one that I just read, I think.
Mr. Libber and Mr. Puckrin, isn't this a convenient time just to take a 15-minute adjournment?
Thank you, Mr. Commissioner.
What time is it?
Adjournment.
We'll adjourn until 25 to 12.
안 나갈 것 같아.
You may proceed.
Mr. Chair, before Mr. Sotoli continues, may I just clarify an answer which he gave through him? To give you the context, the Commission asked him whether a circumvention of the 2 billion rand threshold he regarded as being a breach of faith or unlawful. I might not be quoting the question verbatim. Mr. Sotoli answered that he regarded it as a breach of faith, but not unlawful. May I, through you, just put this question to him? Mr. Sotoli, when you were asked that question, did you mean to denote that you considered the circumvention of the clear injunction lawful, or did you simply wish to indicate to the Commission that you were not qualified to comment on whether it was lawful or unlawful?
Council, the intention was to clarify that I'm not a lawyer by training, nor am I a legally competent person to pronounce on the legality of the action.
Thank you, Mr. Chair.
Thank you. You may proceed. I think paragraph 11.
Commissioner, I will start again in terms of my...
I think there's a question.
Before you move to the next sections, I just want to check the letter marked A3. What effect does it have? Is that a legal, is that an addendum to an agreement or to the mandate? What legal force does such a letter have?
Commissioner, it becomes an addendum to the investment agreement and the mandates, and what will then happen is to also have a formal addendum that is included in the agreement to reflect the contents of the letter. But this is the position that reflects the decision of the board and emanates from a properly constituted resolution that you'll find in the minutes of the GPF board's minutes.
Then another question before we leave the unlisted section. Basically 2 questions. So those are big questions which have come through. So, you know, I just hope they're not too difficult. The first one was raised by General Bantu Lomis, I think, and then it was also AMA GP. And they said that the PIC is wasting money in black economic empowerment transactions, in BE transactions, and they do not see why the PIC should be taking such risks, you know. So can you just please comment, because the GPF has allocated money to BE, just as a first question.
Again, it is a difficult one to answer, but I then can only answer it from the perspective of the GPF. The GPF, as I've indicated at the beginning of my statement, believes that it has a role to play in addressing some of the challenges that the country faces. And it might sound odd, but actually for its own benefit. And I think I'll come back to explaining why I say that later in my statement. But the point is the GPF is a significant investor in the South African economy. And in a sense, if you were to look at the work that has been done, there's a strong correlation between the returns of the GPF and the performance of the South African economy broadly. I'm not saying there's a causal relationship, but there's definitely a correlational relationship. What that means that how the GPF's returns through the PIC largely reflect how the South African economy is performing, given our significant exposure to the South African economy. It is in the interest of the GPF that the South African economy performs across the board, just generally. And of course, more specifically, to address certain challenges that the country is facing, such as the challenges of transformation. Now, I cannot gainsay the opinion of or whoever has a different opinion as to whether it is worthwhile for the GEPF to involve itself in matters of transformation, but I can categorically state that it is the view of the GEPF that it does have a role to play in fostering transformation broadly and broad-based black economic empowerment more specifically. Now, that's all I can say. I mean, they can hold their views. The GPF holds a contrary view.
Then a follow-up question, and I'm not sure whether it's a PIC question or your question, but let me ask and then we can take it from there. So these people say that, you know, BE enriches a few people, all right? And the second point is that we looked at some of the transactions and the BE trusts within those particular transactions. There could be some problems there, you know, because these BE trusts are supposed to be broad-based, but you find that a sponsor would dip into the PIC money, but you find then within the BE trust they got family members and, you know, other people. So you find that actually the BE trust is not really broad-based, and that you know, the trustees are not even known. We don't know the beneficiaries, you know. So I don't know how we can sort of work through that, because this BE trust seem not to be working well, these trusts, you know.
Commissioner, I think there are two things. The one is the intention. All that the GPF believes and wants to do and allocates hard money towards this effect is that we believe that transformation is necessary, transformation is correct, and we would like to play a role in fostering, engendering that. And then, of course, there is the second part of that, which is the execution. And again, I don't think it's necessarily the GPF nor the PIC. The intention is to foster transformation and to facilitate black economic empowerment. And I think we're quite comfortable that we do that, and I'm quite sure that, as far as I'm aware, the GPF will want to continue to do so. We do that with the expectation that it is done properly, both by the parties that are executing on behalf of the GPF and the PIC, so the management of those, the executives, that they actually are in applying their minds to how it is done, that they do proper due diligence, they look beyond, for lack of a better word, the camouflaging of people in consortia, as you've indicated. We hope that in due diligence we do that. But I think it's important to see that as what it is. It is not an indication that the intention, the actual deployment of monies to foster transformation is wrong or shouldn't be done. It is probably indicative of either the fact that we could do the process of due diligence better, and more important, that maybe the parties that we are involved with in terms of investing in entities may not necessarily be the partners we should be doing business with. But I think the intentions are good and they remain.
All right, okay, thank you.
I think I'm now on listed, which is paragraph 11, 11.1. In terms of the investment portfolio structure, risk parameters, benchmarks, and fees, these are included under Annexure B3. The listed instruments mandate covers conventional areas of investment management, whereas assets are well regulated on exchanges, full and partial membership of the Federation of Stock Exchanges. Now, this indicates a point that I made earlier on, just to say that it is important to remember that a significant portion of the GPF's assets are managed in conventional way, as any asset manager would invest in regulated stock exchanges where prices are set by the market and there is no need for concerns around issues of valuation. It doesn't necessarily mean that the investments in those areas are necessarily guaranteed returns in any form. And I think our specific examples can be given that that is not the case. But it does mean that the decision-making processes are not subject to, for a lack of a better word, circumvention, manipulation, or whatever concerns that might have given rise to the work of the Commission.
On the question of fees, both for listed and unlisted, do you have limits to what a threshold is? What their fees? Do the deals include specification of what fees can be included in the deals, and give us some indications, given some of the issues around fees and earnings of fees, advisory fees, etc.?
I'm going to split the answer to two. I think the one is in the listed environment. In the listed environment, the fees that are paid to the PIC are all agreed in advance, and it's a percentage of the assets under management, and that is, I think, it's a standard fee. There might be questions around the size, simply not so much in terms of the percentage that the PIC is being paid, but in terms of the size of the assets that are being managed. By and large, I think the fees in the listed environment are not really subject to any contention. The challenges come in the unlisted environments, and again, in terms of the PPMs, the actual agreement that we entered with the PIC in terms of Isibaya 2 on behalf of the 70 billion, there are agreed fees that have been agreed between the GPF and the PIC. It also makes a distinction between the fees ordinarily paid to the asset manager and the fees that are entered to when transactions are being considered and entered into. Broadly, there are different fees that are agreed, that are provided for in terms of facilitating the transaction, but the details of the fees that the PIC then pays to whoever it engages in the process, that the GPF is not party to, nor does it always have sight on those fees. And Commissioner, some of the information that has been revealed in the Commission is actually new to the GPF itself in terms of the nature and the purported reasons why those fees are paid. Are things that we've learned as we've followed up to the extent that we have the proceedings of the Commission.
Are you going to be looking at that in terms of the mandate to the PIC going forward?
We already have started the review process, Commissioner. May I proceed? During 2017-18, listed equity increased by 10% as a result of possible fair value adjustment and additions. So I think that's purely just what happens in the market, and again, that's not really a reflection of what the PIC has done. Then, to speak about governance, the GPF Board of Trustees and Management have put in a number of mechanisms to ensure that the asset managers, such as the PIC, act within the mandate provided. Some of the structures that are in place include the GPF's board as the ultimate governance structure that oversees the management of the GPF, specifically its investment. And then, of course, there are committees specifically tasked with ensuring that the investments are prudently managed. There's an investment committee, there's an audit and risk committee, as well as a special subcommittee of the audit and risk committee, that is the evaluations committee. This is the committee that looks specifically at the valuation of unlisted investments. It does so after the investments have been valued by independent valuers, and there's a whole number of them. It's not just a single one. There's a whole range of valuers that actually look at these unlisted investments, and subsequent to that, there is an engagement between those independent valuers together with the PIC and the valuation subcommittees of the GEPF. Of course, that does not speak to the processes that are taking place within the PIC itself, which the PIC can speak to. There are also meetings between the boards, so there are meetings between the two boards, the boards of the PIC and the board of the GEPF, and there's also some specific meetings between the investment committees and the social and ethics committees of the two boards. They are not really meetings that are binding. They are meetings where the parties meet to talk about matters of mutual interest and concerns that might be. So they are not really matters that will be followed up directly by any of the institutions. They will have to take it back to the specific committees or boards, and then it will be followed up by the institutions. The GEPF Investment Committee is chaired by the by the GEPF chairperson, Dr. Rinosi Mukate, who is eminently qualified. Some of Dr. Mukate's accomplishments are a PhD from the University of Delaware. She served as an executive director, CEO of the UNISA Graduate School of Business Leadership. She is executive director of the World Bank Group. She was from 2010 to 2012. She was also deputy governor of the South African Reserve Bank from 2005 to 2010. Dr. Mukate is further a member of the Board of Advisory for the School of Public and Policy Administration for the University of Delaware. And as I've indicated, there is no requirement that the chair of the GEPF must automatically become the chair of the investment committee. That is the decision that is taken by the board of the GEPF at its inauguration. The fund is managed according to a core satellite approach, where the larger core is managed more conservatively and the smaller active mandates are managed more aggressively to generate higher risk-adjusted returns. The PIC manages the core portfolios. A portion of the assets is allocated to satellite portfolios where opportunities exist to achieve a better than market performance. Those portfolios are managed by specialists in the identified areas. The Minister of Finance, as I've already indicated, is consulted prior to adoption of the strategic asset allocation, a process that is currently underway and has had the delays that we've spoken about earlier. Because of the size of the fund relative to the local market, it is difficult to generate returns in excess of the market performance on a substantial proportion of the assets. And more specific, given that 92.5% of the GPS funds are invested in South Africa currently, the full 5% allocated for Africa, excluding South Africa, has not been reached. The GPFs indeed also invests in markets outside of the South Africa and, of course, in Africa as well.
A question here. You have been quoted in the media, I think, that the GPF will be increasing its local allocation, the unlisted portion and the global portion. Would you want to maybe comment further on that?
I'm not as important as to take a final decision for the GPF. I think I've expressed a wish, in a sense that the GPF has a significant, what we call a home bias. I think for 92.5% of the GPF to be invested in the South African market, there's nothing wrong with it, and I need to be quite clear that historically this has actually served the GPF very well. But from a risk management point of view, from a need to diversify the GPF's investment portfolio, there is a need to consider diversifying the GPF investments beyond a number of things. I think the South African economy, not because the GPF or I has a distrust in the South African economy at all, simply because that it does provide a risk of concentration in the South African economy. The second part of that is that we are heavily exposed to the Johannesburg listed entities. I think that is also quite a significant area of risk, potentially in the future. And of course, we are a significant investor in the bonds of the South African government and state-owned enterprises. Now, again, I'm not saying that because it's wrong. I think it is quite appropriate in the sense that it matches the liabilities of the fund to the extent that they are South African liabilities denominated in South African currency. So there is a good reason why that is. But in the long term, I think there is a need to diversify the GPF's strategic allocation beyond the listed environment. So increasing our exposure to other assets within South Africa other than the listed environment, and then of course to diversify geographically. Now that is the subject of the discussion that we need to have with the minister in terms of the strategic allocation. So the board has already taken a decision around a review of the strategic allocation, but that is not current in a sense that it has no standing because there's not been any agreement with the minister, and it will only become current once there's been agreement with the minister. So whatever Abel Sithole says on the sidelines has no bearing on what the GPF must do because that's subject to agreement between the principals.
And in terms of your wish, where would you like to see these percentages, the unlisted portion and the non-domestic portions?
I think that there's definitely a need to invest in the unlisted environment because one assumes, and one can always, it can be contested, but I think that to the extent that we correctly invest in the unlisted environment, we then actually investing in the direct economy. So you're funding entrepreneurs who are doing things that are going beyond the big companies. So I think to that extent, I think the consideration to increase our investment in unlisted exposure, if it is done properly, I think it is an area of appropriate diversification. Then, of course, there is the consideration for geographic diversification, and a number of things drive that decision. By investing in South Africa, of course, we support the South African economy, but there's the other reality that we are not actually availing the fund of opportunities that exist outside of South Africa that are not in South Africa. I mean, for instance, if we were to invest in companies in social media, for instance, the big companies are not in South Africa. If you want to invest in say in manufacturing, by and large, a lot of the big companies in manufacturing, say for instance in the car industry, are not located in South Africa. So the need to go beyond the South African market is also to avail the fund of those opportunities that exist outside of the South African environment. And of course, there is the other reality of diversing your currency exposure, which does have direct impact on your returns.
But you cannot give us a long-term percentage, say from 5% unlisted to some amount, or from 5% global to some amount?
Well, again, this is subject to our of the GPF consulting the minister and agreeing to what it will be. But I can make this statement because I think it is categorically correct. Is that the GPF, if you look at it as a pension fund, and it is unique in a number of ways, but it is a pension fund. It comprises half of the total pension assets of the country. The other half, that is in the private sector, is allowed to invest up to 30% offshore. I think you would really struggle to rationalize why it is possible or allowed for private pensions to invest up to 30% of their assets offshore, but it's not allowed for the GPF. Now, I'm not saying that that's what we should be aiming to in the immediate future, but I think if you were to look at it purely objectively, you have to say there is no rational reason that can be proffered to say the GPF should be denied the opportunity that is currently being afforded to the private pensions. But again, I'm not saying it's like a light. You don't press a button and immediately, because the impact on the South African economy would be devastating. But I think over time, that ultimately is the test that one has to apply.
The unlisted portion?
How much should it be?
Yeah, the unlisted. You said the global is 30% is like, the top range.
Again, I would say that we currently in the area of about, in terms of the strategic allocation, not in terms of the money deployed, we're looking at about 5%. I think doubling that would not be untoward.
Yeah, because I think in terms of Reg 28, the pension funds are allowed to invest up to 10%,
Yes.
I think, in private equity unlisted investment.
That's the rationale.
Is that what you're saying?
Yeah.
Okay, thank you. Thank you very much. Thanks.
The investment managers, if I may continue, Commissioner, the investment managers appointed directly by the GPF must finish the fund with monthly reports within 10 business days after month's end and quarterly reports within 20 business days after quarter end. On request, the investment manager shall present the performance, risk, and compliance of the portfolio to the GPF in the format requested and within the specified time frame. The investment managers will then also provide the fund with a strategy review for the prior period and will discuss the likely strategy for the ensuing period. Additional portfolio reporting is provided by the fund's master custodian. If the investment managers are of the opinion that there are sound reasons for possibly not adhering to the guidelines set out in the mandate, the investment manager should approach the GPF's Board of Trustees for consent in this regard. In the absence of any communication in this regard, it is assumed that the investment manager's discretion is not encumbered by the mandate. Should the guidelines in the mandate be transgressed, the investment manager must notify the fund and must prepare a detailed plan of action to rectify the transgression and indicate how the fund will be reimbursed for any losses suffered. The investment management agreement is currently under review, which review is led by an independent consulting firm. The GPF anticipates that it will take 2 further years before the review is complete. Then I move to the questions around IO technologies. It is important to state categorically the PIC did not involve nor inform the GPF when it considered and made the investment in IO. It did not highlight this investment in its subsequent reporting to the GPF. It only started responding to questions asked by the GPF when the GPF learned about the investment and the questions that were asked and its valuation and what may have influenced it. Now, it's quite important to understand that this is, in a sense, a case of the deed was done and the horse had bolted. So you're asking the questions post-effect, but it is very important to be very clear that the GPF was not at all involved in the decision around IO. And the reasons are that way.
Before you continue, IO is one element of the Sekunjalo group.
Yep.
The investments, if you looked at the total, would be just around 10 billion rand or a little under that. Is it only IO that you were not consulted on, or was it also the other investments, Independent Media, Sagamata, and Premier Fishing? Or is this specific, your concern specific only to IO?
I think the response was to the question which focused on IO, but I think I can broadly just speak about the other investments. Sekunjalo as a group, that will not necessarily have been brought to the GPF, but the Independent Media of South Africa, that was a matter that was considered by the GPF, and this goes back to, if I'm not mistaken, about 2006? 2010. And that was prior to my time, but I think the documentation indicate that the PIC did bring the investment media of South Africa to the GPF, and the board considered but did not, and there was discomfort in both the investment committee of the GPF and the board of the GPF around the investment around Independent Media of South Africa. However, at that time, the board believed, and correctly so, that the mandate had not been constrained. So the PIC was acting within the mandate and therefore allowed the PIC to proceed with the decision without, in a sense, other than simply informing the PIC of discomfort, interfering with the decision-making process of the PIC. So and I think the other Sekunjalo those were not brought to the GEPF because they were probably within the mandate of the PIC.
Does that not come back to this question of individual entity within a group and mandate?
Yes, I think that you raised the question earlier, Commissioner. Yeah. The PIC, in its subsequent reporting to the GEPF, contended that they considered that the IO investment fell within the listed investment mandate. The PIC therefore considered that they did not require the GEPF's approval. I do not agree with this. Specifically, in cognizance is taken of inter alia, the definition provided above for the listed investments, read with the above resolution. I think, by and large, if you say something is listed, there is a definition of what is listed, and most people would probably lean towards that definition. And the one that the PIC provided to me does not meet the definition of what is listed. The PIC alleged that the IO investment was made as part of the SIPs, or the Structured Investment Portfolio Investments. According to the definition provided by the PIC, a SIP is a type of investment that contains a product mix with a derivative feature. SIPs are distinct from typical investments due to an underlying derivative in the form of a put or call option. SIPs are used in both listed and unlisted. Primary use is in the listed environment. In instances used in unlisted, this was due to the listing potential of the entities. Now, that's what they have said. And as I've indicated, I still do not share the view that entities that have not been listed for just simplification can be classified as unlisted. It is my respectful submission that if on the effective date and during the interim period before listing, the funding arrangements are legally classified as unlisted or accounted for as such, it is not clear why the funding arrangement will be considered to be listed. In my opinion, it should have fallen under unlisted investments and therefore be above the 2 billion limit of unlisted investments beyond which the PIC needed to involve the GEPF. After the GEPF became aware of the transaction, the GEPF contacted the PIC and requested a detailed report of the transaction, and that the report should indicate how the transaction relates to the previous transactions with Sekunjalo. I think that's the question that you asked me earlier, Commissioner. A copy of the email from the PIC noting this request is attached as Annexure A4. The GEPF sent an email to the PIC noting that the GEPF requested an explanatory memorandum outlining the details relating to the transactions mentioned in the email. A copy of the email is attached as Annexure A5. The GEPF sent a further email, a copy of which is attached as Annexure A6. Therein, it was noted that in addition to the GEPF's request above, the GEPF had read a number of articles regarding Sagarmatha Technologies and the funding thereof. The GEPF requested that the PIC clarify and provide comprehensive information to it regarding all GEPF's investments in companies linked to the Sekunjalo holdings. And again, although this was post-effect, I think it addressed the question that you asked me earlier, Commissioner. The PIC delivered a memorandum to the GEPF, which was entitled Participation in IO Technology Solutions Private Placement. A copy thereof is attached as Annexure A7. The report was dated 16 April 2016. However, the GEPF's board's tenure ended on April 18, 2018. The first time it was formally discussed was in July by the investment. So there was a timing problem in terms of consideration because the previous board's tenure expired, and then there was a process to appoint a new one, which took some time. And by the time the board was properly constituted to consider the matter was a number of months later. An extract of the minutes of the meeting noted that the PIC was asked how the 4 billion investment in IO technologies related to the 2 billion limit, where the GEPF's investment committee and board's approval should have been sought. The PIC stated that they understood that the 2 billion limit would apply to the unlisted investment portfolio, whereas the PIC had made the investment from the SIPS portfolio. The GPF should clarify whether the 2 billion limit should apply only to unlisted or listed investments as well. Multiple investment in the same company could result in amounts higher than 2 billion. Limits across various asset classes should be considered. A copy of that extract is attached as Annexure A8 here too. The PIC's position that the investment did not need the GPF approval from where I'm standing and from the GPF's perspective is incorrect as stated above. The PIC made a presentation to the GPF's investment committee where it explained the investment thesis. A copy of the valuation presentation is attached as Annexure A9. On 24 January 2019, the GPF delivered a letter to the chairperson of the PIC wherein it was specifically noted inter alia that the GPF is extremely perturbed by the recent announcement by the PIC that it has suspended executives head of a listed investment, Mr. Fidelis Madavo, and the assistant portfolio manager, Mr. Victor Siani, following a preliminary investigation report that reflects the flouting of governance and approval processes with respect to the IO Technology Solutions transaction. The PIC executive team had assured the GPF on numerous occasions and in correspondence that the correct governance processes were followed with respect to the IO Technology Solutions transaction. The GPF views this as a serious breach of trust. A copy of the letter is attached as Annexure A10.
A question here, a question from this side. If we could please go to Annexure A7, and I think we're on 14.9, paragraph 14.9, Annexure A7. The question of the valuation of IO, has been canvassed quite a lot here in this commission. So when the PIC responded to you and on this memo, what was your feeling about that valuation?
Chair, again, that's a difficult thing to, I think one can only work with the facts presented, and to us, yeah,
yes,
it's quite difficult to say. I need to, again, to reiterate, you must remember this is post facto. This is, the horse has bolted, so I think you can legitimately engage in what the valuation could have been, but the truth of the matter is that the 4.3 billion has already been committed. So the valuations post the fact, I don't think address the fact that the decision had been made, money had flowed out. So I think I just want to put that in context. But the intention of following up, of course, as you will see in the annexure, is to get to an understanding as to what the thinking of the PIC was at arriving at the decision. Now, this is quite important because different people can have a different view about what investments are. That's the nature of markets. If that wasn't the case, there would be no such thing as a market. You always need to have two people with different views. The one says, I think it's a good investment, therefore I'm going to buy. The other one says, well, I don't think it's going to be a good investment in the future, I'm going to sell. But that's what really makes markets. So the fact that there will always be different of opinions about valuations, I don't think in itself is a strange thing. So that's the important thing. But you then say, well, the GPF was presented with a valuation which included the rationale for the PIC to invest in IO technologies. I think the first thing that the GPF, of course, does is just to note that that is the basis on which the PIC has arrived at the decision. However, there have been other people that have indicated that IO could be valued very differently. And the PIC, I mean, the GPF has also indicated that to the PIC that yes, that's the valuation that you've placed on the investment, but there are people who have come out with good reasons why they believe that the valuation that you're placing on the entity is not what it should have been. Now, that's after the fact, but that the GPF has communicated to the PIC.
Yeah, thank you. You can proceed.
Just while we're on that, and obviously it will be further discussed, and lots of information has come out in the evidence from a number of people appearing before this, so AO will continue to be discussed. But if you looked at page 5 of that same memo, and relating to Sagarmatha technology, point 17, para 17. After concluding a thorough due diligence, PIC decided not to invest in Sagamatha due to its offer price being significantly higher than PIC's estimate of Sagamatha's fair value. How do you read that statement, given the information that I assume you are familiar with, that other evidence has presented before the Commission? Or are you not familiar with that?
I think first I don't understand what the Commissioner's question.
The question is, PIC decided not to invest in Sagamatha. They actually decided to invest in Sagamatha at 39 rands odd per share, although the valuation was 7 rand 6 cents. It was the JSE that did not allow the listing to take place.
Okay, now I think I understand. I think the GP can go with is the statement that the PIC has made. I think what Commissioner you are indicating is that is contrary to the facts. It wasn't the PIC actually that decided not to invest, although in actual fact it did not invest, but that was not due to its own valuation, but to the action of the JSE. I think, so the first one is simply to acknowledge that no investment in Sagamatha was made.
Sure.
Then the second part is that to the extent that the PIC is indicating that it was its decision and not that of the JSE, I think that will be incorrect, and I think we'll take cognizance of that. And I think, again, it's very difficult because in a sense you will be asking the PIC to justify something that they haven't done. So, but I think it is concerning that in a sense they had already made the decision to invest, although it was not finally executed because of the actions of the JSE.
Can I, Mr. Commissioner, with your leave, just follow up before I forget about this annexure? In paragraph 11, page 51 of 7, it reads, at the same meeting, the PMC further resolved to approve the acquisition of a 29% stake in AYO for a consideration of 4.3 billion ahead of its listing on the JSE, subject to the following conditions, and then 5 conditions are listed. In this memo, it is nowhere stated or revealed to the GPF that Dr. Machilla, before this meeting, signed an irrevocable offer to take up all the shares on offer from AYO. When did you find out for the first time about this irrevocable offer being signed before the meeting?
I can answer for myself, not necessarily the GPF, because I don't think it. The first time I heard about the irrevocable was when I think Victor Siane presented to the Commission.
There are 2 points I wish to make. First of all, is the question whether it's legally possible to set these conditions when the agreement has already been signed. That's the one point. But the second point is, in your view, does this memo, without mentioning this signature of this irrevocable offer before this meeting, does that comply with the PIC complying with the FACE Act and acting with the utmost good faith to the GEPF?
I think, well, I don't think it's a fact, because that's what the annexure indicates. On inquiry from the PIC to answer the question that we required of the GPF to answer, that's what they provided. So this is the response that the GPF received from the PIC. And at that time, the GPF had no other information other than to go with what was presented to it, because as you've indicated, evidence leader, at that time the GPF was interacting with the PIC on the basis of the agreement and the policy which expects good faith engagement with the GPF, that you tell us honestly what the situation is. But of course, what surprised the GPF is when and the evidence was presented, and I'm not saying necessarily that's conclusive, and the Commission will probably pronounce on that, but the reality is that there are clear indications that the reporting that the PIC provided to the GPF seems to indicate that they were not quite reflecting what had transpired. So I think that to me is a clear indication. And as to whether these terms and precedent should have been adhered to, I think that's a question for the PIC, because it indicates challenges within the PIC itself, that certain conditions should have been met before the investment was made, in terms of the PIC's own processes, which in hindsight seems to not have been the case.
Thank you.
Thank you, Chair. The GPF requested the PIC to clarify and provide comprehensive information to it regarding all investment in the company's linked to Gunjalo. I think I had just indicated that. And then the PIC delivered a memorandum, which is the A7 that we've been speaking about, as included. An extract of the minutes of the meeting noted that the PIC was asked how the 4 billion, of course, related to the limit, and then, of course, the PIC stated that they understood that the 2 billion limitation would apply to unlisted investment portfolio, whereas the PIC considered this to be part of the SIPs. The GPF should clarify whether the 2 billion limit should apply to unlisted investment or listed investment as well. Multiple investments in the same company would result in amounts higher than 2 billion, limits across various asset classes. I think I'm repeating myself. I apologize for that. The PIC made a presentation to the GPF's investment committee where it explained the investment thesis, a copy of which is provided. Then, on 24 January 2019, they delivered the letter to the chairperson, which dealt with the issue of trust, which I think the evidence leader you were asking about. So the GPF did communicate to the PIC its concerns around the clear indications, although they have not yet been proven, of the circumvention of process and not actually following the processes even within the PIC itself. On the 3rd of June 2019, a further memorandum was provided to the GPF from the PIC, which was titled the PIC versus IO Technology Update. A copy thereof is attached as Annexure A11. The Honorable Commission will note from the paragraph 5 thereof that it states that the PIC has proceeded to issue summons against IO. The memorandum did not state that the PIC apparently issued summons on behalf of the PIC and the GPF. Although I was aware that the PIC had issued summons against IO, I was most surprised when I first received a copy of the summons on the morning of 11 July 2019 and noticed that the GPF had been cited as a plaintiff. I have made inquiries as best as I could in the limited time available, and to the best of my knowledge, no one at the GPF with the requisite authority authorized the joining of the GPF as a plaintiff. I find it significant that in its memorandum to the GPF, the PIC only mentions the fact that the PIC has instituted action that is wholly silent on the joinder of the GPF.
Excuse me interrupting, Mr. Chair. May I just ask Mr. Satoli to elaborate? The summons is annexed to the, is in the bundles. I don't want you to actually turn to it, but have you or anybody else in the GPF, to your knowledge, consulted with counsel on that summons?
No, we have not, counsel. We have not consulted our counsel at all on the matter because, again, we did not know of the joinder until the 11th.
In fact, if you look at 14.13, if I may ask you to go back to it, you refer to a memorandum drafted by counsel to you by yours faithfully sitting on your left. Can I, without in any way destroying the privilege or compromising the privilege in that memorandum, may I just ask you whether you understood that the memorandum said you should take no steps which, in parallel to the proceedings before this commission, so as not to prejudice the commission and to give you the full picture before you took any action?
That is correct. Just to read 14.13, the GPF gave instruction to senior counsel to understand what its rights were in regard to the events surrounding the investment after some of the allegations were repeated under oath at the Commission. The memorandum was drafted by senior counsel and is attached. And I think to be quite specific, counsel has, I think, correctly advised the GPF that we should not act in parallel to the Commission, but that, of course, does not mean that we should not reserve our rights to act as and when the time comes to do so, but we should allow the Commission to conclude its work before any action is taken. So we have received that counsel, and the memo is attached under B5.
Thank you. Thank you, Mr. Chair.
According to the copy of the summons issued on May 29th, 2019, a copy thereof is attached under Annexure A12. The GPF currently awaits the final outcome and report of this Honorable Commission before debating the issue further. Insofar as the summons issued in the name of the PIC and the GPF jointly is concerned, I'm currently making further inquiries how this came about, and the GPF will seek legal advice on the best course of action to adopt. Then to proceed to the Pan-African Infrastructure Development Fund, just to state the facts, during 2005, a proposal was made to the GPF regarding the Pan-African Infrastructure Development Fund, or what we call PADIF, an infrastructure fund managed by Harris General Partners. Now, there's a distinction between these two entities. There is the fund, and of course there is the manager. And sometimes I think it's important that the two are not the same things. And when we deal with them, we must separate the issues that are pertinent to the investment in the fund and how that is managed via Harris. During 2006, the GPF...
Sorry. Just a clarification here. Isn't it that the first company was Harith Fund Managers, not Harith General Partners?
Yeah, no, that's correct. It was Harith
Yes.
Asset Managers. That was the first company that was created.
Yes. So and then in 2012, then
it was
the
changed.
assets of HFM were transferred to HGP.
Yeah,
So we should correct that, isn't it?
That's correct, Chair.
Yes, that is
Commissioner.
HFM.
Yeah.
Yeah. Okay.
During 2006, the GPF Board of Trustees granted approval to invest $250 million in PADIF 1. During this time, the GPF was cognizant of the fact that the PIC had no Africa mandate. During September 2007, PADIF 1 was established. The GPF committed $250 million to PADIF 1. In 2009, PADIF 1 raised $630 million from 10 investors, which included the GPF, although, of course, the GPF was the significant investor. The relationship with PADIF is regulated in terms of a trust deed. The trust deed governs the GPF's rights, including those of other 9 investors, and outlines the obligations of the fund manager. PADIF 1 has 15 years term, and the investment has generated realized and unrealized proceeds to date. PADIF 2. PADIF 2 was a follow-on investment on PADIF 1. In 2015, the GPF committed $350 million to PADIF 2, which is a 12-year US dollar denominated fund. The relationship with PADIF 2 is regulated in terms of a limited partnership agreement. And I think this is due to the fact, as Commissioner has indicated, the change in the nature and the structure of the asset manager. PADIF in general. The governance processes comprise the advisory board and the investment committee. The board is made up of the investor representatives of the GPF, the African Development Bank, the Development Bank of South Africa, the Botswana Public Officers Pension Fund. The investment committee comprises of 1 executive director and 3 independent non-executive directors. The GPF is not represented in the investment committee of PADIF 2, but it is represented in the advisory board. The GPF invested in PADIF as part of its broader mix to diversify its investments from the listed equities to unlisted assets, assist in the acceleration of infrastructure development in the continent, and generate attractive risk-adjusted returns for pensioners, members, and beneficiaries.
Another question here, 18.2 Perhaps maybe you might want to tell the commission, what does an investment committee do, an advisory board do? What different tasks do they do? Advisory board versus an investment committee.
The advisory board plays an oversight role on the activities and the decisions that are taken by the actual functionaries. In this instance, of course, it will be in the first instance in terms of direct engagement of the investment committee, but more important of the managers of the investment. So what will happen is that the executives, the managers of the asset manager will go out and seek opportunities. They will then, of course, once they found what they consider to be attractive investment opportunities, do the necessary due diligence, and then they will present that to the investment committee. And the investment committee then will be the first line of sight to try and agree, looking at probably much broader factors other than what for lack of a better word, the technicians will look at to decide whether the investment was worthy of investment by the manager. And then, of course, if they are happy, then you will have the oversight by the advisory board. Now, the kind of things that, for instance, the advisory board might consider, which an investment committee or the executive might not consider, would be, for instance, issues around potential reputational risk in terms of the ethical issues that might not necessarily be germane to the technical validity or attractiveness of an investment, but might be quite significant if you are now going to make a final decision about investing. So you might find that at a technical level, ethics might not necessarily be paramount in your decision-making process, but when you go to the advisory committee, an issue like ethics might actually be considered as a do or die of that investment. And that's where there's a difference in terms of the decision-making process in the different levels where decisions are taken.
Thanks.
Additionally, the long-term liability of pension funds matches the long-term nature of infrastructure assets. So again, this is just to indicate why the GPF would consider to invest in this kind of investments, and in the past, and will continue to do so probably in the future. Once a year, the investment committee and the audit and risk committee of PADIF convene a joint meeting where they consider the valuations of the PADIF investments in the presence of internal and external auditors. Now this is probably an interaction that takes place more in the PADIF stable than actually with the GPF. In addition to the governance oversight, the GPF receives quarterly reports from the fund manager and also attends the AGM of PADIF, where the manager presents financial matters relevant to the fund, including individual performance of the investee companies in detail. The GPF follows specific approval and governance processes to approve such investments and requests for drawdowns on the committed funds. Both PADIF 1 and PADIF 2 are monitored and overseen by the GPF's investment committee. Now, it's important to clarify what the issue about drawdowns is about. So funds are committed, but to the extent that they have not been investment identified and money are flown to support those investments, the money sits with the GPF. And only after all processes have been gone through and the final decision to invest has been taken, do the funds then flow out of the GPF to be invested in the entity by the PADIF. But until that time, the assets actually remain in the portfolio of the GPF. The GPF is not the only, although it is the largest investor in PADIF 1 and PADIF 2. So they are, as I've indicated, and I've named some of them already, there are other investors in these instruments. PADIF 1 is currently chaired by the GPF's chair, Dr. Rinosi Mukate, already I've mentioned her above. By being directly involved in both funds, the GPF has been able to be intimately involved in the decisions taken which affect the funds committed outside of South Africa. The GPF is satisfied that the fund managers have and continue to fulfill their duties accordingly. Herith was appointed by the PADIF Board of Trustees, which comprises the 10 investors to manage the fund. So that, I think, speaks to the investment in PADIF 1 and PADIF 2, which is a very separate matter in terms of the management of those assets by Herith. Then I move on to Libashe. Libashe Investment Group TY Limited is a special purpose vehicle SPV which was created for the purpose of acquiring Capitec BE shares from the PIC. The SPV obtained loan facilities from the PIC acting on behalf of the GEPF. And again, the decisions around the investment in Libashe did not involve the PIC. Not the PIC, the GEPF. The PIC engaged with Libashe independent of the GEPF. As more fully detailed in a report marked confidential by SNG, the loans were structured as follows. Libashe Investments Capitec, an amount of 719,939,449 rands, and Capitec Ashbrook 1.5 billion. A copy of the SNG report is attached as Annexure B6. The loans have been repaid with interest. Now move on to SA Home Loan. The GEPF partnered with SA Home Loan to make home ownership a reality for GEPF members. Now that statement needs to be understood quite broadly, because the certain processes that took place before the GEPF was involved, and it only in a sense got involved when it was time to actually deploy the funds to back this intention, which is to provide housing for GEPF members. And again, it's important to understand that it was never envisaged as the be-all and all of the vehicle that the GEPF will use to assist in this regards. There are other activities, interventions that the GEPF is busy with and looking at to try and address the housing needs of GEPF members. Of importance and a bit beneficial to members is that SA Home Loans have adjusted the qualification requirements for home loans so as to enable more members to qualify, while ensuring that every approved home loan is affordable in terms of, I say law, and more specific there is the National Credit Act, which specify that, for instance, you cannot apply more than 30% of your gross salary to housing, again, to ensure that you don't become overly indebted. It is hoped that this partnership between the GEPF and SA Home Loan will make the process of owning a home for our members a simpler and less stressful experience. Now, I've used GEPF. The decision to invest to invest in SA Home Loan, and then of course deploy the assets that the GEPF has deployed in this regard. That was actually done by the PIC. And a memorandum of understanding was entered into between the PIC and the Department of Public Service and Administration. And that memorandum of understanding, the GEPF is not party to. However, as it aligned to the GEPF's intention, the GEPF had no difficulties in actually deploying the assets in this way. Now, what that really means is that the GEPF was not involved in the structuring of the investment and who is involved in the investment in its current form. It was purely addressing the need that it saw and deployed the assets accordingly.
Right. Okay, Gina.
But there is a question that arises because the first loan, if I recall, to SA Home Loans was about 9 billion.
Correct.
Done in the manner that you've said. And then the subsequent request for 10 billion. There has been a number of allegations made, and it's still subject to further testimony, that Mr. Masikesa from the Chief of Staff in Dr. Machila's office and Mr. Maponya have indicated that there will be no access to this 10 billion unless they are paid 95 million. Are you aware of this debate? Are you aware of any of these allegations? And given that the funding has not been forthcoming, whether there's any credence to their claim that it is because they have not been paid their 95 million that the PIC and the GEPF funding, and because they've made very specific that the 10 billion will not be forthcoming unless they get their funding. Are you aware of the issue? How have you taken this up with the PIC, given that apart from Mr. Maponya, Mr. Masikesa is from the CEO's office, etc.? I'm assuming you are familiar with it, and what steps have you taken to clarify both to home loans and to the PIC what the position of the GEPF is?
Chair, I am aware of it because, again, I can't say to any detailed level, but of course I've been following the proceedings of these commissions and the allegations that have been made in this regard. I think I'm very much aware of. I need to state categorically that the fact that the GPF has not considered and provided an additional 10 billion has nothing to do with any obligation to any party. And I'm quite sure that when the GPF does get presented with a proposal, should it be in the future presented with a proposal on the 10 billion, it will not be influenced by anybody at all. So whether any individual will claim that they somehow have the ability to influence the GPF decision, I think that is not so. The GPF will make that decision in the interest of its members and will not be influenced by whoever it is. The reason why the GPF...
Just for clarity, sorry to interrupt you. Are you indicating in that there has been no proposal from the PIC for the 10 billion?
There has not been a formal proposal to the GPF for the 10 billion. However, the GPF is aware of the request from SA Home Loan for the 10 billion in that it was copied on the letter that was sent to the PIC by the SA Home Loan. And the GPF has not acted on it simply because the PIC has not brought it to it. That is the reason. And therefore, as far as the GPF is concerned, there's no need for us, well, maybe I shouldn't even go there, other than to say that the GPF will not be influenced by any external party to make this decision. If it ever is brought to it, it will decide in the best interest of the members of the GPF, independent of any engagement by any party. But as we speak, there's been no formal request. There, however, has been concerns raised both by Labour with regard to the potential deployment of money to invest in to provide loan funding via SA Home Loan. Those concerns relate partly to some of the concerns that I think the Commissioner has raised around the involvement of individuals, but they do not hinge on that. They hinge on what Labour would like to see as the GPF and SA Home responding favorably to provide even more benefit to members of the GPF in this process. So what they would like is to consideration of the terms and conditions to make sure they're not onerous, to consider potential beneficial interest rates. And those are the kind of things that the GPF would entertain in terms of looking at any additional funding if it is requested to do so. While, of course, the other issues that have been raised in the Commission will be addressed both, I think, by the Commission, I presume, and the PIC more directly. So those are the kind of issues. Those issues, it's not only Labour that has asked those kind of issues around the terms and conditions and the interest. The Department of Public Service and Administration has also asked for those to be considered should any additional funding be provided. And again, those will be independent of any advisor or anybody. Those are issues that we believe are germane and are worthy of consideration. It doesn't necessarily mean that we'll meet them, but we will consider them.
Just another question there. In terms of the 9 billion that was lent, there's an issue about the underwriting fee. To whom does it go? So, some are saying that 45 million on the 9 billion rent should have gone to the GPF. Some are saying it should have gone to the PIC. Mr. Maponya says this is his money, it should go to him. And then the SAHL says it's not supposed to pay any fees. What's your view on those
That's a
issues?
difficult question. So I'm going to answer purely from the GPF. Who underwrote what? So in a sense, you need to get back and to say, well, if you are claiming that something should be paid to you, you need to be able to demonstrate that which gives you title to that which you are requesting. So whoever, in a sense, lays claim to whatever monies they're claiming to, they need to be able to demonstrate that they've done something to deserve receiving that. Now, the question is, has any of those parties demonstrated the reasons why they believe that they've done something or provided a service or whatever it is that they've done to believe that they're entitled to it. Now, I can say from the GEPF and say, but we provided 9.5 billion, so I have no doubt in my mind that if there is any such funds, the GEPF is entitled to it, not because it has provided the money. So it's not conjecture, it's a fact. That's what we've done. So unless the other parties can legitimately demonstrate why they're entitled to this money, I'm not sure why they would conclude that they're entitled to it.
So are you saying that if there's any money to be paid, that money should go to you guys?
If
To
there's money to
GPF?
be paid, if there is money to be paid,
Yeah.
it should come to the GPF.
Yeah, yeah. What is practice actually? Do you know what practice is in this kind of transactions?
Commissioner, practice is not a theoretical thing. Practice is, have you done something? I think I'm repeating myself, but I think it's important that I do. Simply to say, well, practice says I must do something, I say, but practice is informed by a delivery of something, either a product or a service. And to the extent that you can demonstrate that you provided a product, underwriting, or a service, whatever the service might be, you can't simply claim benefit based on practice. So to me, you need to demonstrate why is that you believe, what have you done, what have you provided that entitles you to this. And if parties can do that, fine.
And if they cannot demonstrate it, you are saying then no fee should be paid? If
That's-
they cannot demonstrate the service
I think
they have given?
logically that seems to follow for me.
Yeah, yeah, okay, all right, okay, thank you.
Despite those questions, Mr. Sitola, I don't think it is our duty to decide and to order who should pay what to whom.
Pardon, Commissioner, I didn't
I'm saying
follow.
despite those questions, I'm hoping you're not going to look to us.
No.
Say who must be
I
paid
think,
what.
no. I apologize, Commissioner. I hope I didn't insinuate that I'm expecting the Commission to do so. I think in the GPF's engagement with this matter, those are the questions that the GPF would ask. What have you done? What have you provided if you're entitled to anything? Okay, Commissioner, may I proceed? Then I move on to EcoBank. The GPF owns 13% of EcoBank, transactional incorporated ETI shares. The current market value of the GPF's investment is 1.78 billion. The returns on investment in dollars were negative overall, all periods to March 31st, 2019. For the first year was negative 19.50, and then for 3 years, negative 19.73. Since inception in June 2019, the investment has yielded in total minus 0.648%. This should, with respect, be seen in the light that the overall GPF's investments have done very well. So I think there might be issue in this one single investment, but again, and I'm not speaking to non-bona fide issues that might have taken place in the investment, but if to the extent that it's bona fide, it is not untoward that the investment might not perform. So because not all investment necessarily will perform. The constitution of the PIC board. We were asked to comment on this. The GPF Board of Trustees has been asked to comment on the constitution of the PIC board. The constitution of the PIC board is provided for in the current PIC Act and is being addressed in the PIC Amendment Bill. And we provide an Annexure 813 as per the Standing Committee on Finance. The GPF's input was incorporated in the National Treasury submission and largely reflects the GPF's contribution, a copy of which is submitted. Now, the important thing here is that some of the questions that are being asked with regard to the composition of the board, I think must take cognizance of what currently exists. And the PIC Act is quite clear, indicated earlier on. It does provide for depositors to nominate potential board members to the PIC board, although of course the final decision remains that of the minister, and I think that is quite in order as the current Act provides. And then with regard to the chairperson of the PIC, again, the PIC Act is quite clear in a sense that it doesn't really prescribe who the chairperson of the PIC board, and we need to distinguish that from the practice. And I think sometimes the practice seems to be understood to be the law, but it's actually not. The law does not prescribe that the chairperson of the PIC must be the Deputy Minister of Finance. It actually leaves that open for the minister to decide who to appoint as the chair. And so far, the decision has been taken by the minister to appoint the deputy minister, but this is not in terms of law. And then, of course, there are provisions that the bill currently provides. To some extent, I think they're probably even more onerous to the extent that they now start to prescribe who the chair is. Well, the current act is. So the question is, which one would you prefer? And sometimes I get a sense that we're trying to fix a problem that doesn't exist, in the sense that the act does not prescribe, and practice is not act, and therefore we need to distinguish issues of practice vis-a-vis issues of law. And to the extent that we do that and we comply with the law as it stands, or the memorandum of incorporation of the PIC as it stands, to the extent that that is complied with, some of the questions that we're asking, in a sense, are answered already. So we need to go back to what originally is provided in the law and act accordingly, or in the original memorandum of understanding, and act accordingly. And if we did that, it's my view that some of the questions that are being asked would not arise, because the law and the memorandum of incorporation deals with those matters. In conclusion, the fund has grown significantly since 1996, and the reasons for that might be contrary to what some people represent. I think some of them are as follows. And fundamentally, and one needs to state this because I think we need to take cognizance of some of the decisions that have been taken at a higher level that we don't recognize at times. When the GPF was set up in 1996, a number of things were done. The first one, well, not the first one. One of the most important things at that time, the fund was grossly underfunded. At the time, I think was 72.6% funded. It was really bankrupt, and I think there was a need to rebuild the fund. A decision was taken to fund the GPF. And that wasn't taken by the GPF, that wasn't taken by the PIC, that decision was taken by government, by the policymakers, to fund the GPF. That's very important, because in a sense, up until that point, the GPF was managed as a pay-as-you-go fund. And that decision to fundamentally fund the GPF is fundamental to the growth of the GPF. And for me to claim that will be disingenuous. Then the second part was to allow the GPF to invest in equities, that is the strategic asset allocation, which until that point in time, the GPF invested broadly in government debt. And it was allowed to invest in the JSE, well, not JSE, to invest in the open market, including bonds of corporates and all that, so it wasn't just the equities. Then again, that was a fundamental decision, not taken by the PIC, and partly taken by the government with the GPF at that time to now diversify the GPF's investments. Now that has led to a significant growth of the GPF to where it currently is at. And then, of course, there is the method that goes hand in hand with that was the GPF setting up the strategic asset allocation of the GPF going forward. So now diversifying the investments of the GPF. That actually is what has been fundamentally responsible for the growth in the GPF. The fund's assets grew by 8.3%. This is in the last year, financial year. Of course, this is not a claim that this will be repeated in this current new year, because there's been a difficult year, but it is simply to state that the fund has grown despite all the challenges that we've been facing, and currently stands at about 1.8 billion. This growth is a vote.
Excuse me interrupting you. I'm not given to discourtesy. Is there only not a couple of zeros missing in 23.2?
23.2, where?
It's billion instead of trillion.
No, it's trillions. Yeah,
Yes.
it's trillions. You are correct, Councillor. It's trillion, not billion.
Just another question there. So the funds have increased by 100 billion rands. Does it include dividends and the interest that you earn?
That's correct. That includes all income.
The full growth
Yeah, that's
is
includes-
capital gains and
Yeah.
the dividends
Yeah.
and the interest.
Yeah.
Yeah,
Correct.
and rentals and
Yes.
other things, all those
Correct,
things. Okay.
Commissioner. Correct. Sorry for that. It is trillion, not billion. I was saying that this growth is a vote of confidence in how the pension fund is managed and how the funds are invested. And just to add that although large in rand terms, and of course, and the GPF and the management and all of us are very cognizant of the fact that every rand counts, the unlisted portfolio comprises less than 5% of the GPF's assets managed by the PIC. A significant part of the unlisted portfolio is actually performing quite well. So although there are these challenges that the Commission is considering, and I think they need to be considered and addressed and dealt with, it is also important to understand that as a portfolio in totality, the unlisted portfolio is giving in returns. And this speaks to your question, Commissioner, around should we be investing and should be investing more? And the answer is, under good management, the answer is it will be preferred that we do invest more, because we are still getting good returns despite all the challenges that may be identified. And of course, there are distressed investments in the portfolio, and we need to state that this too is true. And of course, it is those distressed investments and other matters that have prompted the establishment of this Honorable Commission. The GPF continues to closely monitor and guide the fund's investment team to ensure optimum performance. Of course, we don't foresee this. We would like that it is realized, because that is our role, that is our job. The GPF is awaiting the Honorable Commission's final report and recommendations to further debate any issues raised and of any action that might emanate from that.
Just a quick
Thank you,
one,
Commissioner.
Yeah, I got further questions, but let's go to 23.3. Do you, just in terms of the benchmarking in the unlisted investments, I mean, do you, when the PIC reports on a quarterly basis, whatever, do you do the valuations, or they're done at year end to compare the performance with the benchmarks that you have laid out in those private equity funds, and the other funds?
So, Commissioner, there are two processes which are separate. So there's the benchmarking, the benchmarks to which this unlisted investment are measured against. Those were agreed in advance. So when we deployed, for instance, the 70 billion to Isibaya 2, benchmarks were agreed then. So those already exist already. And then the funds are measured against that in totality. So I think it's important to remember that. Then there's the matter of valuation. Valuations of the investments, again, remember there's no open market for a value on them, is done by independent valuers every year as part of the GPF's review in terms of the annual financial statement as required in terms of GP law. So every year the independent auditors must audit the GPF, and amongst the things that must be audited is the unlisted investments. Now, in the first instance, the valuations are done by independent valuers, both for the unlisted and also the property subjected to the same thing in terms of valuation. And then the independent valuers report to the PIC in the first instance, and then if there are matters that they need to clear, they clear it amongst themselves. And then they come to the valuation subcommittee of the GPF, which sits, I think, for almost 2 days, just deliberating, not necessarily on all, although the evaluation is done on all the unlisted investment, they pick which ones they want to look at, and then, of course, agree on a value, because the attribution of value in the final analysis is the responsibility of the GPF. And then, of course, the evaluation subcommittee then reports to the audit and risk committee, and then to the board, which finally agrees the total valuations, which include either impairments or reversals of impairments.
Chair, I apologize for interrupting, but I need to get some guidance from the Commission. Mr. Sithole has completed his evidence, and I suppose there's going to be further questions, but there is an arrangement with Dr. Machila and his legal team that they will start at 2 o'clock. Must I make other arrangements, or can I just get some guidance from the Commission?
My colleague does have some further questions. I'll consult. And I think if he finishes, then that'll be it from our side.
I have a couple of, can we perhaps have the arrangement that we carry on till 1:15 and take a 45-minute lunch break? Or that we start at 2:15 with the other people?
Yes, you get your opportunity to question before we break for lunch.
Okay, can I then arrange with the other people that we will carry on at 2:15 with them?
Maybe you should say between 2 and 2:15 they must be ready if we start at 2.
Thank you, Mr. Commissioner.
Yeah, sorry. I got 4 questions here, and these have been big questions which have come through, so I wanted to get some opinion on those ones. In terms of transparency of the PIC, there's been talk that, to safeguard its future, it needs to reveal more in terms of investments and listed investments and everything. And sometimes the PIC says it cannot reveal more because the GPF doesn't allow it to reveal some things. So in the event that this commission says the PIC must follow practices that are done by the other pension funds like CalPAS and CPPIB and the others, would the GPF be happy with the PIC disclosing a lot of the information that various people here have said it should? That's the first question.
I think, Commissioner, just I mean, in your example that you give is actually very pertinent, and I think it makes the point very clearly. CalPAS is not an asset manager. CalPAS is a pension fund. So when we talk about transparency of the PIC, and I think we need to be careful that we do not attribute things to the PIC that it is not, or doesn't have, and shouldn't have. The PIC does not own the assets that it manages, and that's fundamental. So I know that sometimes people might want to act as if it does, or allege that it does, and it may well be maybe mistakenly act as if it does, but it does not. The assets that it manages are the assets of its clients, the assets that manage the GPF, the UIF, and the compensation fund, and all the other funds that it manages. Therefore, it cannot disclose information that is not its information. I think the example I can give is this. If I have a bank account with a bank, the money that's in the bank on my behalf is my money. The bank cannot disclose that money without getting permission from me. So maybe the request for the PIC to disclose things is not right, because you're asking it to disclose information that doesn't belong to it. So the correct, and this I think we've been quite clear, and it's been done in any case, although I think people might question it, and I will elaborate. The GPF has been disclosing investments in its annual report all along. So it is not that it has not been in disclosure. What has happened is that we've disclosed historically only the 10 most important investments and the 10 least problematic, 10 most important in terms of value and in terms of returns, and 10 of the most problematic, because it's a whole range of investments. So although there's been disclosure, there was not full disclosure in the sense that not because there was any need to hide anything, simply because in terms of how much can you put in an annual report. So you give what you believe to be meaningful information rather than just information for the sake of giving information. So there's always been disclosure of the GPF's investments. However, then the request comes, but actually we'd like to see everything. And then in 2017, we still keep the annual report the way it has always been, disclose what we think is materially important, but also disclose the detail of everything else, but outside of the annual report as an annexure. I think first electronically, and I think we've continued to do that, both at the PIC as well as the GPF, or a link between the GPF and to disclose everything else. So the question of transparency, in a sense, to me, is moot, in a sense that I think there's always been disclosure. It's been a question of the extent to which disclosure must be made. So if you want impairments, you can go back to as many years as you want. You'll find the impairments disclosed. It may well be that the detail of any interest that somebody is invested in is not disclosed because the size did not, according to the GPF, justify disclosure. So should we disclose going forward? The answer is, of course, we can disclose, but the distinction is this, and I'm using CalPAS as an example. It is not the asset manager that's disclosing, it is the pension fund that is disclosing.
So do we get an assurance, say, if we say we need some transparency, that the GPF will actually be willing to do that?
Okay. Well, I think the facts speak to that. That's what's happening currently. But I want to go back to, and I might have misunderstood you, Commissioner, so you must let me know if I have. There's a difference between disclosure of investments. There's a different matter about the disclosure of the processes by which the investments are made. Now, the implications for the two, I think, are very, very different. So the disclosure investments, if you're saying, do you need an undertaking, and the GPF hasn't given me authority to say this, but I think they've done it historically and they continue to do so, so I can't see why they wouldn't undertake to do so in the future. So I can almost categorically say that the GPF has absolutely no difficulty disclosing into the future, but that is the disclosure of investments.
Yeah.
It's a different question if you say, that should an asset manager, the PIC, disclose the processes by which it makes the decision that it makes? That's a totally different question altogether.
Yes. All right. Okay. Nice. Second one, it's in terms of the fees charged by the PIC, from the GEPF. If we come up with a different kind of a model, operating model, that needs more money for the PIC because for efficiency and other reasons, is the GPF happy to look at increasing fees for the PIC, given that there's a new model coming through?
Whew, that's another tricky question. You must remember that, and I think I alluded to this at the beginning, there's no law that says the GEPF must use the PIC. And again, I don't have instructions from my board, but I think this is logical. And if that is the case, if a model were to be put in place that was not suitable to the GPF as an asset manager, and again, I'm not saying it will be easy, but I will assume that the GPF will be allowed to consider whether it wanted to continue with the PIC under that model, or it will seek to do something different. And I think, to me, if a model is changed that does not fit, and again, I'm using the GPF and the PS as an example, but you can use that as the relationship between any owner of assets and the person that manages their assets, so any pension fund and any asset manager. If the asset manager changes to the extent that I, as an asset owner, I'm not comfortable, hopefully I have the right to decide to use somebody else. So that's the first obvious kind of requirement that if you were to change the model to the extent where the GPF is comfortable, that the GPF will be given the right to think and act differently. However, let me come back to assume that that's not the extreme, that things are still workable. Well, I think you need to understand, why is the GPF continuing to use the PIC as it currently needs to do? And part of that I might have maybe alluded to in the conversation that I've given. On the larger part of the GPF's portfolio, the PIC has performed according to mandate and delivered our returns in terms of benchmark. So in that sense, the GPF has no, in the bigger scheme of things, does not actually have concerns around that. It might have concerns about the governance and challenges of governance, might have concerns about management, and some of the revelations that I think have been made in this commission might have concerns about that. But that needs to be understood in the broader context of the PIC's management of the GPF assets and the returns thereof in totality. And so to change the structure of the PIC before you have considered that, I think, to me, will probably be remiss. So that I think I'll make that statement. Then number two, what drives the investment that the GPF is making through the PIC is actually not the PIC. It's the issues around the strategic asset allocation, and I think Commissioner asked earlier on about the progress thereof and whether one should be concerned or not. And that, to me, it's a lot much more germane consideration than the PIC as an asset manager. Because why? As I've indicated, 70% of the GPF's portfolio is by and large managed conservatively. For lack of better words, it's actually tracker funds. Now, if you're doing management that way, whether you use tracker fund manager 1 or tracker fund manager 2 or 20 different tracker fund managers, you're tracking the index. How much different will they track the index in execution? Not much. So fundamentally, to the extent that the GPF portfolio is managed conservatively, I think it will be, what's the word I'm looking for? It'll be disingenuous to want to split that, because the consequences of that will be to have more managers managing money for more fees, and therefore, to answer your question directly, the GPF will not be happy to pay more fees without actually the prospect of getting better returns. Why? Because you will be averaging more of the same and paying more fees, and therefore you'll pay more fees and actually getting a better return. So to the extent that the recommendation is to, with a bigger part of the portfolio, to do anything that requires the GPF to pay more fees with almost, and I'm saying guarantee advisedly, guaranteed lesser returns, I think the GPF will not be comfortable paying those fees.
Just the final question here, and briefly, is that, and it's a controversial question, so, but I'm going to ask it because it's quite relevant. And I haven't seen the GPF actually answer the question somehow. Some people are saying, given that the economy is in the doldrums, there's a surplus at the GPF of 137 billion or something like that, why can't the Minister of Finance or the President actually take money from the GPF and sort of have an economic stimulus and boost the growth of the economy?
It's a very good question.
You know, and why are other pension funds actually not doing that? I mean, the GPF has put in 5% into unlisted. Why don't DBAs or whatever pension fund do that also?
Well, I can answer for other pension funds, but I can answer for the GPF. The GPF is cognizant of this fact, and I think I alluded at the beginning, it's cognizant of its size and the role that it can play in the economy, and to the extent that it can, it does engage in conversation, and it does allocate assets to try, to the extent that it can, assist in the economy. But let's go back to your question. Now, when people say that, I think they need to remember a couple of things. The first one is, and this was not taken by the GPF, this was taken by South Africa Incorporated, by government. Do you want, the GPF is a separate legal entity, it's not government. I think I made this point at the beginning. So that's quite important. So are you saying that you want government to dip its hands in the assets of a legal juristic entity that is separate from itself? So if you're saying minister must dip in, what you're saying is minister must come to you, commissioner, if you are super rich, and simply dip his hands in your pocket just to fund South Africa's problems. Because you and the GPF are the same entity, you are two separate juristic entities. So from that perspective, the fact that people say it must happen like that, I'm saying in law it can't, because the minister has no authority to do that. Otherwise they will do that with any other juristic entity or any personal entity out there, number one. Number two, the government itself decided that the GPF not only will be a separate legal entity, that it will be funded. So the government took that decision to fund it. Now, it is true that the funding comprises a very significant part of South Africa's assets from the fiscal point of view.
Or even savings, yes.
Yeah. So it is true that but a fundamental decision has been taken. So unless you reverse that fundamental decision, that question again is moot. So if you're to say, well, the minister should simply ignore that the government in wisdom, and I think that wisdom I will support, that the fund must be separate and it must be funded to protect the interests of its employees. To the extent that decision still remains, again, that question to me doesn't make sense. That now you just almost pretend as if that decision has not been taken and it has not been applied for the last 15, 20 years. You will now forget all that and now dip into the GPF. I don't understand that. So again, it's not my opinion, it's just what government itself has decided. So that's the challenge. However, I think the people that are asking the questions, I think do ask valid questions, but you then need to answer those questions in relation to the facts that I've presented. Otherwise, I don't think you can do anything otherwise.
But it's something that you would support. I mean, is that something you support, or philosophically you are against it?
Now you're asking me, okay, again, let's state the facts.
Yeah.
When people say pension fund must support government or state enterprises, you must start with the facts. Mm-hmm. And again, I can speak about pension funds broadly, mm-hmm. but I can speak about the GPF much more because that's my job, that's what I do. Mm-hmm. As we speak, and I'm using the annual report from last year, we're busy currently finalizing the new annual report, and I don't think there'll be any significant change to these numbers. The GEPF is a significant supporter of government through buying government debt. So when people say you're not supporting government, that's not true. We are a significant supporter of government as it stands, with over 300 billion of government bonds in our books. Now, what the government does with that, how they deploy that, I can't say, but I can make the statement that that's what we do. I can further make the statement, which is true, you'll find this in the annual report, is that we support state-owned enterprises. We are the biggest supporter of state-owned enterprises. Now, by doing that, I'm not condoning whatever the challenges those institutions have experienced in terms of governance, in terms of management, whether executive or not. I'm not condoning that. I'm saying to the extent that these institutions, your ESCOMs of this world and your SANRALs of this world, play a very important role in the economy for the benefit of all South Africans, and more specifically for the benefit of the GEPF's investments broadly, because if ESCOM's lights go off, these lights go off, the lights on the streets go off, the mines and my baker neighbor who bakes bread, and I've seen him suffer because of this fact that power goes off and dough goes rotten. To the extent that it's important for that, our funding of state enterprises is quite well informed, well considered, and it actually gives us very good returns that match our liabilities. We're actually a bigger support of that. So when people say, but you need to do more for government, I says, no, start with the facts. Because the facts are the GEPF is a pension fund, and this applies to other pension funds as well, because we're not the only buyers of government bonds, although we're the largest. We're not the only buyers of state enterprises bonds, although we're the largest. Pension funds already are providing support. As to what happens with that money after it's been deployed, that's a different matter. So before we can consider any additional deployment of funds by the GEPF and other pension funds, we need to answer the question, is this money being used properly? Now, the GEPF can't do that. That's for somebody else to answer. And I can say this, if whoever wants funds were to come to the GEPF, have a good business case, bankable projects, so to speak, that safeguards the investments that we make, ensures that we'll get the returns that support the promises we've made, the GEPF and any other pension fund will actually be able to support those initiatives. So the question sometimes is not what funds are doing to support, is what projects, bankable ones, that are well managed, well governed, that can give security on the investment and also good returns, do they exist? And sometimes I think that's probably for South Africa the bigger question.
Thanks. Thank you very much. Thank you. You've answered me. Thank you.
All right. Mr. Commissioner, I have a couple of brief questions, and I'll make an agreement with Mr. Sithole that we can deal with it in 5 minutes. I will be brief in my questions, and I will agree with him that he will be very brief in his response. Mr. Sithole, the first question is, were you aware that the PIC may have been acting for many years now, not within the memorandum of understanding of the company?
No, lead councillor, we were not.
Thank you. Secondly, why did you decide on Harith being a startup fund manager when you invested in PIDF1?
Now this goes back to the investment in PIDF1, I think the creation of PIDF1. The GEPF did not decide on Harith as an asset manager. The GEPF was approached by the PIC at the time, and Harith did not exist, to invest in infrastructure and in the continent. And it considered that, and it thought it was a worthwhile environment to invest. But that decision was not necessarily the appointment of Harith.
Can I perhaps help you? We all know by now that Harith was the creation of PIC.
Yes. Yes.
Thank you. And what I don't understand is that apart from the seed money they provided for the establishment of Harith, that was repaid with interest, they since then had nothing to do with Harith. You invest directly in PIDF 1 and 2, but the PIC is paid huge dividends from this investment. Is that fair? Is it correct?
Evidently, the Commissioner, it is a fact. I think that is happening, and the reason is as follows. So the GPF was asked to invest in PEDIF 1 and other investors as well. And then the PIC, as you've correctly indicated, then created HERITH. And when it created HERITH, it then allowed for the investors in HERITH to have a share ownership, the investors in PEDIF 1 to have share ownership in HERITH in proportion to the investment that they had made. And the strangest situation is that, of course, the GPF had put about 40% of the total outlay for PEDIF 1, while all the asset investors got a proportionate share in HERITH, the GPF did not. And to this date, the PIC owns that. And I think it is a method that the GPF needs to follow, because the GPF should be treated like all the other investment and get the proportionate share of its ownership of HERITH in line with its investment in PEDIF 1.
Thank you. That's the point I was trying to make. I've got two more questions. Do you know anything about the Erin investment?
Erin.
Erin.
Okay. Again, this happened before my time, but again, in terms of documents, I'm aware of the investment in Erin. And Erin originally was a company called KMAC, and then it's changed its name to Erin. So the answer is yes, I'm aware of it.
And do you agree that it was a very poor investment? It's in liquidation at the moment.
I totally agree that it is. It has proved to be a better investment in hindsight.
Lastly, and we stuck to the 5 minutes. Thank you for that, Mr. Sithole.
Thank you.
You were very diplomatic in the conclusions of your statement, and I read between the lines that you don't agree that the PIC should claim all the accolades and praise for the growth of the GEPF fund.
I'm a mathematician by training, so I tend to deal with facts. So I think the facts, and as I've indicated, those are the facts. So whoever claims credit for things that they claim for, they need to be able to explain with facts why. And I think what I spend time doing is to say some people can claim the accolades for what they are, but it may well be an indication of their lack of understanding of why we are where we are.
Thank you, Mr. Commissioner. I've stuck to the 5 minutes. That's all my questions to Mr. Sithole.
And that's appreciated. Thank you, Mr. Libber. Mr. Putman?
Mr. Chair, those are all the questions, but may I testify anecdotally? I had invited Mr. Sithole for lunch, and he told me in no uncertain terms that the fund has an absolute inviolate principle that they will not be feted and lunched, even lunched, by senior counsel, but he has offered to take me to lunch, and I'm aware of the fact that even I couldn't make a dent in 1.8 trillion rand. Thank you. That's all the evidence for Mr. Sithole.
Thank you, Mr. Putman.
Thank you. Thank you, Commissioners.
Mr. Sithole, thank you so much. We appreciate your time, and we appreciate you putting together your statement. Certainly, you have given us much, much more than we expected, and have cleared up certain things that were unclear. So thank you very much. I hope it won't be necessary for us to call you back for whatever, but may I just warn that we haven't had a look at all the annexures. You might be called back to come and explain one or two of them. And
Thank you, Commissioner, and if Commission calls us, we will come back.
Thank you very much. For
Mr.
now,
Commissioner,
you are excused.
is it then fine that we agree till 2:15 for lunch?
Yeah, we shall adjourn until 2:15. Thank you.